Right. Good evening, Mayor and trustees. I'm Stephanie Anderson. I'm the HR manager. So the town of Wellington is a member of the Colorado Intergovernmental Risk Sharing Agency, or CIRSA. And CIRSA provides the town's liability insurance and also has many other resources for risk management and best practices. CIRSA currently serves 283 municipalities and affiliated entities. Sam Light, he serves as general counsel for CIRSA. Sam presented, he's over there. Sam presented to the board back in April of 2022, an orientation. And now that this board has served together for almost a full year, he's back here for a refresher to really provide continued education and support to our elected officials. So I'm going to invite Sam Light up.
Thank you, Stephanie.
Of course, and you'll just hit the arrow.
Oh, great. Thanks very much. Good evening. Great to see you all again, Mayor, trustees. Thanks for having me up. It's hard to believe it's been a year, and it's the first day of spring. So we get got that going for us. I'm glad Stephanie stated the full name of CIRSA, because I always feel like I have to apologize when I state the whole name because it's kind of a mouthful. But yeah, as mentioned, one of the things CIRSA does is we provide elected and appointed officials training. So we thought I'd come back up for a refresher. I think when I visited last April, we had, was it 4 brand new trustees, and then we had some veterans as well, and so on and so forth. So how are things been going? All wonderful. Yeah, great. And as Stephanie mentioned, I get out and do refresher trainings for elected and appointed officials. I thought tonight what I would do is touch base again on some of the core risk principles that I think are important to the job at the governing body level. And then if any questions have arisen around these issues that you'd like to talk about, I'm happy to take questions. But I do want to just unpackage a little bit in more detail some of the things we talked about last year. And I'm happy to also tell you what's going on at CIRSA and what we got on our radar. But before I forget, I really think at a risk management, from a risk management perspective at the governing body level, there's kind of 3 core principles that I encourage folks to keep in mind in terms of managing risk and elevating your performance as individual trustees and as a group. And it's probably these 3 things. One is to remember that it's a 24/7 job, right? I'm sure it feels that way sometimes, right? By that, I don't mean, don't give up your personal life. Please have one and please enjoy it. But, from the eyes of your constituents, the eyes of the citizens, they will always perceive you to be a public official, right? And I'm sure you interact with citizens in the community and here and there, and you're out and about. But, from their perspective, they will always perceive you to be a member of the Board of Trustees, a representative of this organization, and a representative of the institution of council, right? Now that been at it for a while, you interact with citizens every now and then, you bump into them, right? And they may come up to you and say, hey, what's your personal opinion on this thing that the board's up to, right? And we probably, hey, well, okay, I recognize that's a board issue, so I can't really assure you what's going to happen. We're going to have to talk about that as a board, but what's your personal opinion? And you know how it goes. Well, this is my personal opinion. This is my personal opinion. This is what are your constituents filtering? Public official, public official, public official, right? So that's why I mean it's a 24/7 job. And so from that perspective, as they should, our words, our deeds, our conduct matters, has an impact, leaves an impression, right? For a citizen who believes that that interaction didn't go the way they thought it should, it could leave a residue, right? And in a worst case situation, it can create liability scenario potentially. So that's the one major takeaway. It is a 24/7 job. Number 2, service on a collective governing body. Though there are certain aspects of the work you do where you're individually championing the organization, you're out there being the eyes and ears of the organization, empowering the organization by touting its successes, and some of that work you do individually. But at the end of the day, being on a governing body is a we job, right? And at the end of the day, local government work is kind of like a train, right? It's going where it's going. There's really no endpoint. It's more than a train. It's a train that just keeps going. And those of us who are in this, we get on and off the train at certain point in time, but we all want on behalf of our community for that train to get to where it wants to go. Right? And I think in terms of risk management, that means commit to the idea that we're all on board that train together and we're all working together, right? So you can still have disagreements and have healthy debates and deliberations around things, but we're all ultimately working together to get this community where it wants to go to its destination. And the we part of that is committing to working together to move down the track, right? And commit to make the institution of the Board of Trustees stronger. And I commend to people, leave the institution of the board stronger than you found it. And that's a legacy of leaving, right, this board as an institution in the town in a great place. The last one is a little more of a legalistic concept. You know, I know on the ballot it says trustee, but underneath that, from an attorney's perspective, what that really means is fiduciary, right? The concept of legal fiduciary, you're all bound by, and that's really the concept that what do we all, you know, understand fiduciary to mean kind of in the general sense? Putting the interest, from an attorney's perspective, it's the interest of the client, right, is paramount and must be put before all other interests. But as elected officials, the concept of fiduciary means the interest of the organization, the interest of the town as a town is the paramount consideration in the work that we do as a team. So those are my main overarching takeaways before I forget what those are. I do want to touch a little bit more about transparency and electronic communications, tell you about some of the things going on in my world, including hot topics to the extent we have hot and exciting topics in municipal liability and municipal insurance. We do have some. We'll talk about organizational structure and liability a little bit, and then a little bit about ethics and personal conduct. Dan wasn't able to join us in person, but I do have to make my standard disclaimer, though I am an attorney. This is not an attorney-client communication. You'll want to rely on Dan if you have a question about the burning legal issue of the day, or Patty and her team if it relates to administrative matters. All right. We have at CIRSA, among our 285 members, I will tell you transparency stuff has really gotten on our radar the last couple of years. I'll tell you one of the reasons for that is I think there's a fair number of folks, there's kind of a rising trend of governmental watchdog activity in the claims world, right? Why is that? Well, there are a lot of people with vested intentions, right? Expect us to be transparent, and they're going to hold our feet to the fire in transparency, right? A little bit more cynical, but from a claims world perspective, what I see at the tail end of these disputes is there are more claimants and more attorneys willing to take on claims related to violations of the open meetings and open records laws, right? Sometimes they do that because they have an underlying substantive issue. Sometimes they do that simply because they're championing good government, right? Sometimes they're doing that because maybe they want to raise to press attention some issue that they're upset about, either related to transparency or their underlying issue. But as a former newspaper reporter, one thing I know is that what do newspapers like to report about? Transparency in government, right? And so, yeah, so they're going to hold our feet to the fire too. So even if you never end up with a claim situation, right, where we have an actual litigation, right, we know that news organizations like to report on open meetings law issues, right? And that has an impact, right, on communities' faith and trust in government, right? So we always want to make sure we're committing to high levels of transparency. Oh, and by the way, I may have mentioned this last April, you know, whatever that looks like in terms of a commitment to transparency, consistent with the resources that you have, embrace that, right? As the governing body, it probably cost you some budget dollars to do these kinds of things, right? But your citizens will appreciate that. They may not always pack the room and give you a standing ovation for your commitment to transparency, right? But they appreciate it, right? Because if they get home from work at 8 or 9 o'clock and they're just interested in some town issue and they can jump on your fantastic website, right? Jump on there and find out quickly, hey, what's on the board's agenda? Can I look at a past packet? Can I see the minutes quickly? All of those things, you know, we may not know what's going on, but it allows them to keep their eyes and ears on us, right? If we empower them to do that. And it absolutely builds faith and trust in government. So let's talk about a little bit, let's revisit the open meetings law. You remember the basic rule there, the openness requirement of the open meetings law, right? It says that whenever 3 or more trustees meet to discuss public business, that's a meeting that has to be open to the public. And then the second requirement is that if the board is going to take any kind of action, then that has to occur in a duly noticed public meeting, right? Staff takes care of your postings and so on and so forth, right? We all know, and this has been true since 1996, when the statute was amended, but we know that a meeting includes any kind of gathering, whether it's in person, like we're doing now, by phone. Do you have phone meetings? Yeah. Or electronically, right? When they added that phrase in 1996, they meant email. All right, but what are the other modes of communications that applies to? Who loves Zoom meetings? Right, Zoom meetings, right? Who loves texting? Is that an electronic means of communication? Email, right? So all of these are electronic modes of communication that are subject to the openness requirement of state statute, okay? Doesn't mean we can't use those tools. We just need to understand some of the rules around that, okay? So I said the rule, here's a hot topic in my world. So the statute says that the openness requirement applies whenever 3 or more members gather to discuss public business. So it's a rule of 3, right? 3 or more. So that must mean one-on-one's okay, right? Yeah, one-on-one is okay. What do you think about this dynamic? What about one-on-one? Is that okay? That's the hot topic that's out there these days. And I don't have a one-size-fits-all answer, but I can tell you from a risk management standpoint, probably how that shakes out is if in an actual claim situation, if the evidence that comes in suggests, right, that one-on-one was being used as a substitute, right, for deliberations that ought to occur in the board chambers, right, or that the action taken in the boardroom at the meeting was what they call it in the judicial opinions is if it appears that it was a mere rubber stamping, right, of a decision that was reached outside the meeting, that's where the risk lies, okay? So that's the one-on-one issue in, by one-on-one's got a lot of different names. They call it daisy chain meetings or serial meetings. In Texas, they call it a walking quorum. And I love mentioning that because I just have to work that phrase because it sounds so Texas, walking around, getting a quorum, right? And so that's the issue. And the reason I mention now, you've seen it on the news probably a little bit, right? We've been following the Douglas County School Board litigation around this issue. And I don't know where the ultimate facts lie in that case or what the situation is, but they're in the middle of a lawsuit where the plaintiff says, well, I agree. I'm not alleging that the elected members met 3 at a time. I'm alleging that they met one-on-one, right? And probably the fact, if it's true, I don't know if it's true or not, but the fact that probably works against the governing body in that case is there's an allegation that this is a situation where they flipped power on the school board and 4 members confirmed, the allegation is they confirmed one-on-one that they each were in favor of terminating the employment of the superintendent. And the related allegation is that 2 of them then met with the superintendent and essentially said, well, the votes are there to terminate you. Would you rather resign or be terminated? Does that sound like an action was taken? Or a decision had been reached? Yeah, so that's the risk around that issue, okay? And so we'll have to see how that shakes out. The reason I mentioned it to us is we just need to be self-policing on these issues, right? Technology is certainly fine for certain issues and one-on-one meetings. I don't want to understate that, yeah, sometimes that is part of the job. You sit down with a colleague for coffee just to get to know each other, right? Being elected officials sometimes requires some relationship building, even among members, right? We get to sit down and talk about your general view and how you doing and that kind of thing. That's perfectly fine. But we don't want it to be a substitute or a proxy, right, for deliberations that must occur in this room or for taking a decision. I think that's where the risk lies. What I worry about for you in the larger context is that if we don't self-police on that issue and the press or the legislator believes, through horror stories that they hear that there's some enormous problem going on in this area, then I worry about the legislature writing a prescription for some perceived illness, right, that is far more than what's necessary to cure the problem. And then our flexibility is reduced. To give you an example of how that can happen in Texas, they did write a walking quorum rule they actually have a statute that says if local government officials use one-on-one meetings with the intent to evade the open meetings law, then that's a violation of state law. That was the original version of the bill. It was challenged on constitutional grounds and it was found unconstitutional for some technical reasons. They rewrote the bill a second time and said, if elected officials with the intent to evade the openness requirement of the Texas open meeting law engage on one-on-one discussions, then not only is it a violation of the statute, it's a misdemeanor. What? That's pretty heavy-handed, right? So that's why I emphasize that this is a hot topic and something where we need to be careful about that. Now, having said all that, one-on-one meetings are absolutely fine. Just recognize, right, that if we're doing that, that we're not doing it to check in with each other individually, like how are you going to vote, or and that kind of thing. That's where the danger lies. Now, we are allowed to have meetings, including meetings electronically. In 1996, they amended the statute to say that emails are subject to the openness requirement. And that just simply means that if 3 or more members use email to discuss the merits or substance, right, of public business, that's when the openness requirement is triggered, okay? But the state legislature back in 2021 passed a bill that actually gave us some clarity that certain types of emails are just fine, even if all 7 of you are talking to each other by email. And these are what some of the safe harbors are. The actual language of the statute is it says that email communication between elected officials that does not relate to the merits or substance of pending legislation or other public business shall not be considered a meeting. Okay, so in my claim world, I tell the claimant, if it's 7 of you are all trading emails about the barbecue that you're all going to, and it's purely social and purely social event, that person doesn't have a winning open meetings case just because 7 of you are on an email thread. Okay, more to the work that you do. The legislature said that there are certain areas that are safe harbors, even if all of you are on the email thread. Okay, and that is if the emails concern scheduling and availability, that's just fine. So if Nathan sends out an email that says to all of you that says who's available for a special meeting, and all 7 of us respond to each other and we're copying each other, which seems natural because we all want to know who's available when. That might help expedite getting the meeting set. That's going to be fine, not an open meetings violation. Email sent for the purposes of forwarding information. So if you're working on, I don't know what your legislative priorities are, but if you're working on a potential ordinance to allow backyard chicken hens, I'm going to borrow that because Patty told me that she has backyard chicken hens. If that, if that's the ordinance, if that's the ordinance on next week's agenda, and you're kind of doing a little bit of your own research on the topic about the pros and cons, and you find a nice article about some issue about how they can create some nuisance effects, you can email that article to all 7, all your 6 colleagues and say, hey, FYI, here's an interesting article. Thought I'd share it in view of our upcoming discussion about the chicken hen ordinance, and that's just fine. The problem would be if people start responding going, oh, that's interesting, that's why I'm going to vote no, and here's other reasons I'm going to vote no. You can also copy all of your fellow he can run back to asks that we do what? Try possible that they're all same plane of information. That comes up quite often, like if the packet comes out and you're getting ready for next week's meeting at a land, and it doesn't seem to be a packet. I thought that was administrator could be prepared to address then is doing something, but it's not showing up. Just keep going. Any discussion, debate, or exchange of ideas, either generally or specific, related to, and I love this word, related to the essence, right? So effervescence, right? The essence of any public policy proposition, specific proposal, or other matter being considered by the governing body, right? So just intuitively, we understand that if the exchange of email or the one-on-one discussion is in that area where this feels like a deliberation, right? This feels like what we ought to be doing as a board in the boardroom, then you're right. And that's where we need to be on those issues, okay? As part of my materials, I've got a handout that
I'm sorry, can I interrupt for just a second, ask you a quick question? Because you're giving reference to like one-on-one meetings, and there are times that I meet with the mayor and a rotating trustee
Yep.
once a week. So there's two of them and one of me, and we do talk, we like go over the agenda and
Right.
things like that, what's happening in the community. We're good with that?
Yes.
Perfect, thank you.
Yeah, the open meetings law only applies to the governing body members, the body, and not to administrative staff. So two of you meeting individually with the administrator is fine. Okay. Or something similar to that. Okay. Is also okay. One of my handouts talks more about the issues around emails. So any questions about use of email? More in terms of risk management and the actual substance of emails. My main takeaways are, I boil it down to sort of almost euphemistic at this point, but of course, as a public official, thanks. Separate from the openness requirement, right? So two people can have an email exchange that never triggers the open meetings requirement. But the state law says that in general, correspondence of elected officials is a public record, right? And subject only to some narrow exceptions that staff will advise you on, you should assume that your email communications, right, can be subject to a core request. And if there's no clear basis for non-disclosure, then we're required to turn those over, right? So getting out of the weeds, that leads me to suggest, right, don't say in an email anything that you wouldn't want to say in a public meeting, right? Or read in the newspaper, or have read back to you in a deposition. And that's my world. In the claims world, so much of what goes on is about, not about we want it to be what happened at the meeting, and it should be. That's where the deliberation needs to occur. But from the claimant's mind, right, their concern is they want to see the emails too. So when people say, well, how do they find these things out? Well, a lot of controversial decisions, immediately after that, people who were not satisfied with the outcome, they may file a court request. They just want to learn more about whether this was discussed, right? And so so they're looking maybe for further explanation of what the thinking was behind this. Well, I encourage you to do all that on the record during the meeting, right? So if we get those core requests, then sometimes they just end up turning over just a fairly innocuous set of emails. But sometimes if we're not, right, honoring our commitment to transparency, then there's emails that like get close to the line. And then the claimant starts looking at those email threads and goes, oh, now I see there's 3 or more trustees on these emails. Now, I was just wondering whether they had email exchanges about this topic. Now I see there might be an open meetings problem, right? So be very circumspect in that regard. I think the phrase is Luddite. I don't mean to be a Luddite. I'm not anti-technology. It's just that you need to have a handle on these concepts around it. absolutely, you can use email for administrative purposes, but not for the discussions around the merits or substance of items that are pending in front of you. Okay? Any questions about that stuff before I pivot? All right. Who's active on social media? Anybody? Okay, there's a lot to unpack there, and I actually do separate trainings on risks around social media. Just a couple of things to get on your radar. I think when I came last April, I handed out everyone one of these. If you don't have one, I brought a few more copies. There's a chapter in there about social media, and with my apologies, it probably raises more questions than it answers, but it just highlights some of the risk issues, okay? Recognize that I think social media is also an electronic means of communication. So the openness rule still applies. We'd like to think that social media is fully open and transparent, right? But it's not. It's only open to people who are liking us or following us or those kinds of things. So there is an open meetings issue there. You don't want to use social media for discussions of 3 or more trustees around a matter of pending public business. There are First Amendment concerns. We've seen that, read about that in the press. If you have a social media site and do any of you use your social media site to do your job as a trustee? Yeah, so if you do that, then we know the golden rule about content regulation. You're all now governmental actors for purposes of First Amendment liability, right? So the thing we've seen is, you don't edit or remove content or remove people for the content of what they're saying. There's some very narrow exceptions to that, but is a good risk management tool. Here's the good news. I think last time I checked the statistic, I think there's 300 billion social media posts a day. So something that seems like, it really makes me mad, that comment, by the end of today, that's going to be yesterday's news, and it's going to disappear down that thread. So part of the world we live in as elected officials, sometimes you're just going to have a thick skin and let that stuff roll off, but we don't block those people, right? We don't remove their comments. That's just all First Amendment protected speech, again, with limited exceptions. I'll leave the other two alone. Other than the last bullet here, I just want to mention, having said that, I do recognize that sometimes elected and appointed officials and public employees can be on the receiving end of, I guess, less than courteous social media traffic, maybe even snarky, maybe even attacking, right? There is this evolving world of law around the really bad stuff that I worry about, and that's true threats and doxing. Okay, a true threat is a social media post where, from the perspective of a reasonable person, one could only conclude that post or thread was a threat of imminent physical violence to an individual or their family. So I mentioned that here just in terms of risk management. If you ever perceive that is what's happening to you, just first recognize you're not alone. But in this world, it's kind of a strange world we live in. Sometimes people get really close to the line, but they're also, they're pretty sophisticated and smart. They get real close to that line, but they know where the line is. And they may be trying to get a reaction out of you, right? If they're not acting in good faith and or maybe they're just believing that their job is to self-police First Amendment rights, First Amendment order type activity, they may know exactly where that line is. And they may be trying to press you to respond in a way that's they believe will violate their First Amendment rights. So if that's happening, just recognize you're not alone. You have resources. Check with your staff. Patty and Dan and her team can help. Law enforcement, if it's a threat to imminent harm, can look at this and help you look at it and say, well, is there anything that can or should be done about this? Sometimes the answer is, and we help our members on these issues. We have our First Amendment attorneys look at these once in a while. So it's unfortunate. It's a sad commentary of some of the things that happen on social media, but there's nothing we can do with that. On the other hand, that violated, right, some state criminal statute, and something can be done about it, but who would do that? Law enforcement. So they would be our friends in dealing with that. Okay. A couple more tips on social media. So if you're on social media, well, and the people who knew you're on social media before you became an elected official, they still know you're on social media, right? if you want to keep your personal social media personal, you have every right as an elected official, like if someone DMs you, DM, is that right? DM, yeah. And they want to talk to you as a trustee. You all have town issued email address? Yeah, you have every right to say to that person, hey, this is my personal Facebook page or my personal social media site. Could you contact me at this email address? If you'd like to talk to me about town business, you can do that absolutely if you want. Now, there's another thing that I see go on once in a while. If you're reading, do you have a next door or something like that? Or maybe you have more than one. What are they called? You got next door anymore? So, you like to peruse that and see what people are saying out there. But and now you're reading this thread, and it's just all this blatant disinformation about the town and the board of trustees, and you're just thinking, this is so wrong. We got to fix this, right? So I would encourage you to think about, as an organization, as a board, as an institution, do we really have to do that? Do I really have to jump in? Am I the right person to jump in? Should I jump in, right? If we're committing to the we aspect of this, right? I encourage you not to think of it in terms of, I'm so mad about this. What's the impact on us as a board? Is this just something that's going to roll off? Hey, that's a parallel universe and they're just doing their thing out there on social media. And that's fine, because we got our world here, right? And this is the place to come for good information, right? If there's disinformation going on. So think about that. If we really feel like there's a need to correct this information, consider carefully the who, the how, the when, and the where, right? In a lot of situations where members are asking us for suggestions, we say, well, maybe the way to do this, if it's a high profile issue and there really is some stuff where we as an organization, if we just put a little bit out there would help clarify a misunderstanding, then maybe is it a retweet or is it a post? Hey, for those who are interested, you can go to the town website at this address and find information on this issue. And then we're done. Those who would like to go there will, those who wouldn't like to go there won't go there anyway. But we've taken a small step without putting ourselves at risk in terms of jumping into that fray. Okay. All right. Let's any questions around all my transparency topics?
I do have one question
Yes.
for you on the social media thing. So, can you also refer someone so what I typically do is if someone messages me on my private Facebook, I ask them to message my trustee Facebook Messenger.
Yeah.
If they have a comment or send an email, that is still acceptable,
Mhm.
correct? Okay,
Mhm.
perfect.
Yeah, as individual governmental actors, your biggest risk factor is if you actually had a social media site that operated as a governmental site, i.e. it had the trappings of looking like a tool for communication in your official capacity. If you blocked users on the basis of what they were saying, or you remove comments based on their viewpoint, that's where the major risk lies. None of that prohibits you from expressing a preference as to how you'd like to hear from individuals, and you can tell them, no, please don't contact me here. Please use this if you want to talk to me. Okay. The other thing we tell some elected officials is that, remember on Facebook, there's a light switch on there too, right? If the comments at some point are unbearable, well, you can turn the light switch off entirely, or you can have the light switch on entirely, but you can't have it in the middle. It's not a dimmer switch. It's an on or an off, right? And so we had some issues on the West Slope, and one of the elected officials there was under attack on social media. And his conclusion was, well, I can either just take the site down, right? Or I could just turn off the comment feature entirely. And I'll let everybody know I'm doing that. And I think he actually decided to take the whole thing down. But there's nothing in municipal law that says that if you have a Facebook page that you have to actually toggle the switch that allows comments. Now, there's other reasons, dynamics at play. It's like, well, if I want to communicate with the community, why wouldn't I want the switch on? Fine, as long as you're willing to accept the fact that no matter what's said, unless it's in that very small basket of things that you can actually do something about, then I'm not, whatever they say, it just rolls off. Yeah, okay. Let's talk about, last spring, I mentioned in general, the concept of organizational structure and liability. Let's just touch base again, on what that is. Again, the good news being you've got liability protections, of course. And we have a good statute in Colorado, the Colorado Governmental Immunity Act, that says the town, right, and by extension, town's insurer, CIRSA, is going to defend you and pay judgments entered against you for acts or omissions as a trustee. Good news. And there's a catch to that, right? Those protections apply only so long as we're acting within the scope of our employment and not acting in a willful and wanton manner, right? So just to reemphasize that scope of employment piece, right? Now, it sounds odd to an elected official because you're thinking, I'm an elected official. I'm not a full-time employee. What do you mean scope of employment? Isn't that for Patty and the staff? They got to worry about scope of employment because they're employees, right? That phrase scope of employment is simply the phrase that's used in the liability statute. And it has meaning for you in this way. It simply means that everyone in the organization, whether you're an elected official, appointed official, full-time employee, or even a volunteer, right, has a certain set of duties that are authorized to them, meaning there are other duties that aren't authorized to them. And therefore, everyone has a job description. So as long as we're staying within our job description, that protection sits nicely there to protect us. I'll give you an example. Simple examples of how this works. Do you have business licensing? And that's the clerk's responsibility?
It's finance.
Finance director. All right, so who within our municipal organization, right, within whose job description, within whose scope of employment is it to decide whether or not someone gets a business license? Finance director. Whose job ain't it? Everybody else, right? And that's pervasive throughout municipal organizations, and it runs the other direction as well. Within our organization, right, within whose job description is it to decide whether or not the town of Wellington incurs debt? The Board of Trustees. Whose job ain't it? Everybody else, right? And so that's the scope of employment piece. And so as long as we respect that aspect, we're in a good spot. The other exception to that is we can lose those protections if we're deemed to have been acting in a willful and wanton manner. And I'll just touch on it real quickly. Willful and wanton conduct is intentional conduct designed to injure someone's legal rights, taken with reckless disregard for what their rights are. I can even boil it down to my two favorite words on this topic. I just call it bad stuff. Right? And that's what it is. And we know what it is. We're going to stay far away from it, right? But it's just that intuitive idea that if we're found to have engaged in malicious acts or criminal activity or fraud or something like that, then it's intuitive that the statutory protection that's intended to protect me in my capacity as an elected official would not apply to those things. So I asked my claims people to tell me what's the most common. We don't get, knock on wood, too many of those claims of allegations of willful and wanton conduct. But I asked the claims people to tell me, well, what's the most common situation where this allegation arises? And they said it's usually an individual elected or appointed official or staff member, right? Individually misperceiving that they have some governmental authority that they actually don't have, right? Throwing on that purported cloak of governmental authority and doing bad things to people for the wrong reasons. And and it really would be bad stuff. You know, it would be an appointed official, for example, not thinking clearly and conscripting a staff member who's also not thinking clearly into going on a, campaign to make sure that their business competitor lost their business license, right? Or misusing public office for some criminal act. My double whammy comment here is that your insurance follows the same principles because your CIRSA coverage protects you as an elected official, right? For acts and omissions in your capacity as an elected official. So your insurance has exclusions, right? We don't cover civil liability that flows from criminal conduct or from malicious acts or from willful and wanton behavior. So that's how those course and scope concepts work. The good news is those protections just sit there And they're in the background and they protect you as long as we're all committing, right, to role discipline. And we're just understanding that we're all swimming in a lane, right, within our particular lane, but we're all supporting the organization. From a liability perspective, it is important to kind of swim in one's lane and not have a unfettered water polo match. And that would be that kind, it's not efficient anyway, right? And it creates questions about, well, who's in charge of what, right? And it disempowers your supervisors, right? If they thought under the code or under your policies, it was their job. If we're taking over their job, then who's doing your job, right? That kind of thing, all right? All of this begs the question of what is the, oh, there, thank you. I thought I broke the computer again. Begs the question of what is our job description as the governing body? What is within our scope of employment, right? So you operate as a statutory town. You have a board administrator form of government. That's the most common. It's either council manager or board administrator form of government. That's a wonderful place to be. It creates this structure, just like a private corporation, where you get to be the board of directors of the corporation, because this is a corporation. And we just don't call it the board of directors. We call it the board of trustees. And so you, within your job description, is the things that board of directors do. And then within your administrator's purview is doing the things that CEOs do or chief administrative officers do. There really is that separation of powers. And I've cited some of the code provisions within your own code that talk about that. But state statute expressly says that you are the legislative and corporate body, the governance wing of the organization. You're the only legislators in the organization. So embrace that role, right? And under your ordinances, your town administrator is responsible for the day-to-day operations of the organization. If you look at it in graphic terms, like a hierarchy, where does the board spend its energy? Right? On the left-hand side of the slide, you're looking at the ownership and governance piece, delivering good governance, right? Supporting the institution, championing the organization, empowering it. The role of elected officials within that structure is you're the ones uniquely qualified in the organization to look at the bigger picture stuff, policy making, looking forward, future planning, annual budget. That's probably the most important document you interact with, right? The 1, 3, 5 year capital planning, master planning. So your administrative staff deals with the day-to-day and you look at the longer time horizons, but also the critically important piece of that is the stewardship piece, right? Empowering the organization, being stewards of the organization and champions for the organization in terms of, and so how does that translate into what I do? That annual budget, that translates into your vision of how you want to be stewards of this organization and move this entity forward. So that system of government does recognize there are guardrails. In the consultant guru world, they call that executive limitations probably, or something similar to that, right? Where you've already had a hand in setting those, or they've already been set by state statute, right? So that staff's not unfettered. They have to get the work done within the guardrails that have either been set by you or by state statute, okay? As I mentioned earlier, nobody hands out, I mean, I probably asked this last April, nobody gives you a copy of the code book anymore in hard copy format, do they? 500-600 pages of ordinances, right? But those ordinances, right, have all manner, right, of rules around how we do things both procedurally and substantively. And as it relates to this organizational structure and liability, it has all sorts of allocations of authority that are there to serve you and to protect you. They serve you because they're an expression of either the state legislature when they assign certain things to the municipal clerk, or of you when you assign business licensing to the finance director. They're an expression of a policy that says we as the governing body will handle certain things. And if you take care of those, then it frees us up, serves us by giving us more time to do the things that the legislators and governors do, right? They also protect you as long as everyone's committing to role discipline. Because to borrow my finance director thing, I have an easy claim that I can win for you when that claimant says, well, my business license got turned down. I think I'll sue everybody. I'll sue the town, I'll sue the finance director, and I'll sue each and every one of the trustees individually. Well, I'll hold up the org chart and we'll tell the claimant, hey, didn't you read our org chart? It says the finance director is the one who's allocated the responsibility for the business license. So the only proper defendant in that claim is the entity, the town of Wellington, and the finance director in his or her official capacity. And as long as there's no evidence that anything different was going on, then you're all protected and you're easily dismissible from those types of situations. Okay. Getting out of the legal realm of that, recognize that other things that you do, including some of the individual work that you might do, that's all in service of the job. Are you, do you have, you don't have a commissioner structure, right? Okay. So there used to be this old style thinking that each and every elected official ought to be a commissioner of something. So we at CIRSA, we try to encourage people, well, you have a commissioner, it's called the manager. Right. And so you didn't want that role anyway. There's a lot of liability risk around it. You don't have it. You probably have a softer version of this called, but it's only with relationship to your subordinate advisory boards. Do you have liaison roles? Yeah. And what's our role there? What's our role there? Yeah.
Primarily to listen and bring questions that they have to the Board of Trustees or bring information from the Board of Trustees to the advisory board.
Yeah. Yeah, the liaison, I think it's like even the standard dictionary definition is it's a conduit for communication in view of building mutual relationships, right? So I would encourage you to look at it that way. I think the liaison role is still a part of the job that even though maybe you were there the night when we were asking, the mayor was asking for liaisons and we raised our hand, or maybe you were absent that night and you were conscripted into the role of liaison for this or that. But it's in service of the board, right? It's there to be eyes and ears for the board and maybe provide some input as needed, right? Just to perhaps emphasize some guidelines or guardrails about this is what the board asks of you, but make sure you give those advisory boards the room to do their work too independently. Because we all created them. Those are subordinate groups that we wanted to help serve you, but have their own independent opportunity to develop a recommendation and have a discussion and do heavy lifting on your behalf. So, and I think that helps if we think about those individual activities being in service of the we, right? I mentioned this last, but just to move along quickly, that idea of a we job is just remember that you actually, you do every action of a board requires that we do it as a board in a meeting. There is no analogy that sticks that says, well, I'm on a 7-member governing body. I own 1/7 of this power and I'm going to go use it. That the code book just doesn't say that, except for the mayor's presiding officer role. There's nothing in the code that says the powers of a board are exercised individually by individual members. Okay. Last thought on these concepts is just to recognize that sorry, I got disjointed on my page. One second. That the commitment to the we and to role discipline sometimes ask us to do things personally that are in service of the institution. Things like setting aside a personal agenda when there's lack of support. Right? Even if my individual legislative preference was I want that chicken hen ordinance, right? But I got to get 3 members to come with me, right? Or I got to be willing to shelve that personal agenda in view of the service of the work plan of the board as identified by the board. What do you think about this dynamic? Do you have split votes? 4-3, 5-2. What do you gotta? If you're on the 3 side of a 4-3 vote, what do you think? You can go to your constituents or the people you answer to, and you go. It's okay to say, I didn't vote for that one, right? Is that okay? Is that okay? Yeah, yeah. But even in those split votes, do you have the right to do that? Sure, I'm just the insurance guy. far be it from me to tell you, you don't have a right to go back to the people you answer to or take your counsel from and say, I didn't vote for that one. But would the message be different and stronger, right? And more in service of the institution if we said, yeah, I didn't vote for that ordinance or whatever it was. But you know what? We had a really strong debate at the board meeting. We had a lot of different opinions and I fought like heck from my point of view, but you know what? The board decided to go a different direction and I support the voice of the board. Yeah. That's making the institution stronger as an institution. And it's showing people that you have faith and trust in the institution of the we. And we're all going to win some and lose some, right? So we do the things that make us stronger no matter where we end up on the vote. And I think that serves us well and builds faith and trust in government because it shows folks, as you know, you don't get to make 100% of the people happy 100% of the time. Particularly on the tough issues where you have a split vote, how you deliver that product of good governance and how well you decide to say, this was a good debate. Yeah, I didn't win this one, but I respect everybody's point of view and I commit to the voice of the board. That really does show your community that even in tough times, we're going to get the work done as a we, right? And that'll serve you well. All right, last risk management point on this is, so do you all once in a while bump into a citizen who's got an idea for you? Or he's got a question for you? Yeah. So just remember, on the we job aspect of that, sometimes you're going to sense that they ask me a question and boy, depending on what I say, they're really going to take it to the bank. If it's a board matter, right? Remind them, hey, I don't know, this is a board issue. I've got my own views on this issue, but I can't assure you what's going to happen. Or do you have citizens that come up to you with something that's not a board issue? Hey, I've got this building permit problem with the building official. Can you help me out? Yeah, that's when we want to recognize. Yeah, I can help you out. I'll give you the manager's phone number. Right. So use your manager as a resource for those kinds of things, right? To help unburden you from those, but also help, get things done on behalf of the community. Because our citizens, sometimes they don't, you're the face of the organization in terms of interacting with people. And so they'll come to you naturally. Right. But if it's not something that we can help with, it's administrative matter, then we want to do it in a mutually supportive way. We'll say, oh, it's not my issue. We at the board level don't do that, but let me get you in touch with the town manager. The manager will reach out, make that contact, answer the question, let you know that they answered the question. And hopefully next time you see that citizen, hey, did we get you the answer you need? Hopefully it's yeah. And, oh, great. Or, no, you didn't. Well, we're always open to constructive. If no, you didn't give me the answer you need, I wanted because your policy doesn't allow it. Well, that's okay. Right? We just said, then you got another tough call to make. Right? We never said, well, okay, but that's our policy. That's the town's policy. And if we're going to change policies, we have a process for that too. So that does require that we kind of champion things in a mutually supportive way. But remember, your manager's there to help you run interference with that. You don't have to feel the tug of, I know that from a citizen's perspective, you got to deliver me the answer or the results I need now, but we get a bad rap in government sometimes for being deliberative, but that's for good reason. Because the flip side of that is our citizens, our communities expect us to be even-handed and predictable. And sometimes that takes time to make sure we get it right. And you'll always be in a good spot if you just remind them, hey, hey, what's going on? I passed it on to the manager and we'll be in touch. We'll get to you as soon as we can. All right. Couple other things that, as fiduciaries and as stewards, remember the calling is to consider issues on their merits alone, to remember that you don't have wards, right? You're all elected at large. Yeah. That even though you may feel this pressure to get pulled one way or the other by a small but vocal minority, the fiduciary obligation is to all of your constituents. So from where you sit, what I encourage people to do then is, particularly if it's a risky decision you're about to make, is be selfish in your right to take the time you need and get the information that you need to make decisions that you think will be in the best interest of the community. So, I hope probably doesn't happen all that much, but even if in the heat of the moment you feel like, hey, this is not ripe for decision tonight, right? That might frustrate some people that you didn't make that decision tonight, but if you feel like you need to deliberate more at the next meeting, or you need a little more information from staff, then it serves you well to get that information. You do want to resolve to speak with one voice in your interactions with your direct reports. By the way, you supervise the manager, the attorney. Is that all of it? The judge? Yeah, if you want to commit to speak with one voice, by that, I don't mean, I'm sure Patty's more, feels comforted when it's unanimous, would you say unanimous, unanimous consent or all thumbs up. But even if it's difficult situation, right? You just want to commit to speak with one voice, even if you have to put it to a motion. You know, the mayor says, wonderful discussion. Let's all give Patty some direction. You got one idea of direction. You got another idea. We got 7 different ideas of what the direction is. Patty, have you got your direction? Yeah, but who owns that issue? You do, and you want to own it. You have to own it. You have to, and to make the institution stronger. One of the dark arts that mayors practice so well is they'll recognize sometimes, well, this is an intractable issue this evening, but let's commit to bring it back so that we can give direction to our staff. And the liability risk issue that I've seen is if it doesn't happen, it breaks down. And then maybe people are dropping by the direct reports office somewhere later saying, well, hey, you know, that was a messy discussion the other night, but here's what I want you. Is that consistent with the we, right? So we have to say, we'll bring it, and no matter, I assure you, no matter how difficult the issue or how intractable it seems, you will get there if we're having good deliberations around the issue, and we'll ultimately get there. Okay, there's a slide about ethics. I do ethics presentations separately, but just remember that you want to check out your code of ethics, make sure you understand the rules around conflicts of interests. Some of the hot topics going on in my world are the common interest exclusion. That's the idea of, oh, maybe you've got a land use application and you happen to live in the neighborhood. Do I have a conflict because I live in the neighborhood? I don't know. Talk with Dan. Right? But yeah, in the general world of ethics, either because there's an express common interest exclusion or because the standard is direct and substantial, or a tendency that would step over one line or the other, that there's embedded in all codes of ethics, essentially a common interest exclusion that says if the interest is the same as one that is shared by a large group of similarly situated people, then it's probably not an actual conflict of interest. That may not be the end all, right? You may still want to consider appearances, right? Because as you know, in this world, sometimes perception equals reality and reality equals perception. So conservatism around matters of ethics is good, but you're not alone if you face one of these situations. Recognize you know, your attorney, your manager are not individual ethics advisors. Make sure you appreciate that point. But you know, they've been around these things and they can give you guidance from their perspective as, you know, in their official capacity of what this is what we think the code means, and this was what would be a good course to take as a town official. But you have the right ultimately to make the call. Although I do think in your code of ethics, the board gets to vote on certain matters, right? Okay, so campaign contributions have been a hot topic around that. I just leave it at that unless you have a question. And conflicts involving the entity wearing many hats. I'll just unpackage that real quickly because you may wonder later what that bullet is about. I've seen more people saying, how can the municipality enter into a development incentive agreement with a developer and at the same time be the zoning authority? Because when they enter that agreement to incentivize the development, aren't they saying they're vested in the development and now they got to stand in judgment of the zoning question? How are they actually being, you know, conflict free in that situation? So the answer to that is actually under the law, there's a presumption of regularity. And there's also, you're entitled to presumptions that though you wear many hats, that we're all competent to figure out what hat we're wearing and making sure what box we're operating in with regard to any particular decision. And we'll carry out those functions in good faith. And so that sounds like an attractive sort of conflicts argument, but unless there's evidence that there's a problem, you do have the presumption that you can discharge differing duties wearing different hats. Yeah. All right. Lastly, beyond ethics, commit yourself to high levels of personal conduct. I've just listed a couple here. Some of which are discussed more in our handbook. But in terms of wrapping that thought up, just recognize that it's a wise body that if there are issues of inappropriate personal conduct going on, then we need to recognize what those are. And even if it's a tough discussion, we have that discussion in terms of making the organization stronger. And then each individual commits when there's items of personal conduct, personal choice, that we identify and engage in behaviors that strengthen the institution of the board as an institution. Okay. So with that, unless you have any questions, my concluding thought is just to embrace wise leadership. I touched on some of these last year. For the new folks in particular, but for everyone, we've kind of learned in the last year, there's a lot of things we can't control, right, around risk, right? And that's, public perception, you don't have many claims going on, if any, but we can't, in my world, we can't control the action of the claimant or what the judges might do or what the state or federal legislature might do, but there are certain things that we can control that do translate into good governance and helping reduce our risk. And among those are things like, commit to a no surprises approach with each other. Commit to meetings that are free of gotcha moments. They ought not to have that surprise concept. They certainly ought not to have staff bashing. Even if it's occurring, you have public comment periods, Mayor, there. Even if it comes, out of the blue during a public comment. If someone's attacking a staff individually, right? Do we have an understanding of how we might handle that? We might say to that person, public comment is to address the board on matters of interest. It's not to talk about personnel matters, right? Tout your successes. By the way, on that personal issue, even in the face of a personal attack against staff or one of you, imagine how empowering it is to the organization, and particularly in staff, to say, hey, we don't accept that, It's also empowering to you as an organization, to you as a governing body, and to the organization to tout your own successes. A lot of times the negative issues get a lot of energy, but you're doing great things all the time. Take time to appreciate the work you're doing for each other and that your staff's doing for you. Yeah.
I said a question. I appreciated what you had shared about, someone's going off on staff or
Yeah.
member. How do we balance that with First Amendment?
Yeah.
How do we balance that? Because it's like, especially if they're mad at me and they're coming up here to yell and scream about how horrible and awful, how do we balance that? Because I don't want to be trampling on their First Amendment to share their concerns, but what's a good way to balance that?
Yeah, if they have a First Amendment right to say it. It's a question of whether we're going to take up the issue. But you also have a right to ask for decorum. Yeah, if it's disorderly conduct, your law enforcement has the ability to actually do something about it, but it's usually not that. It's usually an attacking comment or that. Yeah, you have a right to ask for decorum, right? And I don't know if you have any, but some municipalities will have guidelines for public engagement, and they'll post them or have them somewhere. And it's things like, we ask that you address the board. We ask that you speak only to matters of town business. We ask that you be respectful of other people's time. We ask that you not use obscene language. We ask that you not engage in personal attacks. There's a fair amount of First Amendment activity around that concept, but it's absolutely true that in general, a guideline that says thou shalt not engage in personal attacks will not withstand constitutional scrutiny. Okay. But I think the flip side of that is we never worry about the liability risk if we, just by our own behaviors and the way we react to that, for 99% of the people, it shows them where we're at as an institution, as a governing body. We could still say, thank you for your comment, but just want to remind you, our public comment period is not a proper forum for addressing personnel matters, and we'd ask that you be respectful, right? And we're going to do that with a proper tone and temperament ourselves. We're not going to take the bait and start arguing with them and let that elevate, right? Escalate, but we can ask people to be respectful. And, sometimes, I can know it can be tough. Somebody stand up during personal public comment and the mayor says, yes, and, we ask that you get anything on your mind. And the first thing, attacking you personally and individually, And even though our norm of conduct is we don't engage in back and forth, we're just, oh, I gotta say something about that, right? Well, there's nothing you can say in the moment that's gonna change that person's mind, probably, right? So if you really feel like you have to always say something, I would encourage you, don't say it in the back and forth. You're gonna get in an argument and it's just gonna escalate probably. Maybe at the very end of comment, if you feel like you need to go on the record, you just say, Mayor, can I just want to put one comment on the record? I want to say that I respectfully disagree with some of the characterizations of my conduct or something like that, and leave it there, because you're not going to adjudicate that issue anyway, right then and there. Wasn't part of the agenda, it may not even have anything to do with, yeah, that kind of thing. Okay. I think it is important to set aside time to tout the great things you're doing and staff is doing. It helps to show, and do you all feel like there's a kind of rising tide of incivility in local government or in government in general?
Yes.
Yeah. But you have, I encourage you, it's always civility, even in the face of incivility, right? Because you do have, can't control everything, but you can control the way you react to things and the expectations that you have for each other and appreciation for professionalism and kind of pivoting away from negative things. You always can tout your successes and the great things you're doing for the community and that your staffs are doing for you. And if you embrace the fiduciary and stewardship role, the we, and always support the institution and the town as an organization, you'll continue to do great things, and your risk issues by and large will take care of themselves. So with that, thank you, Mayor. I'm sorry I ran over a couple minutes, but thank you for the invitation to come visit you again. I'll certainly take any questions if you have any, understanding that I've run over a little bit.
Oh, all right. Thank you very much.
Thank you. Yeah, good to see you all. I'll leave, I think you have most of the handouts, but I'll leave them behind so they're there if you want to grab them during the break. Thank you, Mayor. Thank you.
Next item.
He's coming.
Megan will present the next two items. Hallie wasn't available to come tonight.
Sorry, I was concerned about.
Bob. No. Back. Yes, sir.
And his ankle.
It's the same ankle he hurt.
So that this is hopefully really fixing it this time.
Customize the jeans form.
Good evening, Mayor and trustees.
Hmm.
Megan Smith, Update Director of Public Works. Sorry, guess I haven't been up here in a while and I forgot all about how to get connected. So apologies for the delay. I think I'll be up here for the rest of the night though, at the Megan show. So we are coming tonight with a couple of water related topics. First, we're going to talk about raw water requirements and cash in lieu equivalent. So this is an opportunity for us to have a discussion. I was actually anticipating being at our circle and not at the dais, so forgive me if I rock a little bit. So you guys did have a packet material this evening, a memo along with the presentation that you're going to see right now. So I'm going to kind of roll through this so that we can get to the question and answer part, as I'm sure you do have some questions. I did want to, I believe I had a little miscommunication with the agenda item. It did kind of still maintain a title on that said Water 101. This is a little bit less of a Water 101 discussion. I'm going to touch on it a little bit. It is really more related to how we ask for our raw water requirements, how we base those raw water requirements. That's really the volume of water we ask for. And then how do we calculate or determine what that cash in lieu equivalent would be, should we decide to accept cash fee in lieu of water dedication. So just to give a little bit of background though, we do have 2 sources for potable water production here in the town of Wellington. We have what we refer to as the Wilson wells. These are 3 wells that are decreed for municipal use. They were the original source of water for the town. We are decreed for up to 400 acre feet of use from those wells on an annual basis. There's some maximum flow limitations as well, but generally speaking, we're not as worried about that. It's more about the total volume decreed. About 30 acre feet of that is used every year for non-potable irrigation between Poudre School District and the town of Wellington in this area right here of Library Park and the ball fields, Icestone Elementary and the middle school. So fundamentally that leaves then about 370 acre feet available for potable production. Beyond that, we have an agreement, pretty unique means to get raw water for the town, an agreement with North Poudre Irrigation Company, who is our our irrigation ditch company that serves the majority of northern Colorado up here in our region. That agreement locks us in for 2,000 up to 2,000 acre feet annually out of Reservoir 3. That agreement also dictated use of land adjacent to Reservoir 3 to site our water treatment facility. As you guys are aware, we had some successful negotiation efforts resulting in purchase of that property. At this point, our last step is waiting to go in front of the Board of County Commissioners. We're on the agenda for March 27th. That's the last step before being able to close on that property with North Poudre. So hopefully that should happen in April. That negotiation reduced an administrative fee on that existing agreement that we should see a reduction in an annual payment of at least, or a savings of at least $125,000 a year. Some years more than that probably. Now, just to give a quick overview, what is a raw water requirement? And I kind of put this definition on the screen here, or in your packet. It is a water requirement by new development so that the utility has adequate supplies to provide safe and reliable water supply for all water users under a wide range of hydrologic conditions. So that's one thing I really want to emphasize, is that raw water requirement is that's not about today. That's about planning for tomorrow and well beyond that, right? So the long-term future of the community.
I have a quick question. Is
Yes.
that a municipal code requirement or a statutory requirement for development?
I know that it is in our municipal code, but I don't know if it's a statutory requirement. Dan just texted me, so if he's listening, I could give him a hard time for not being here. I do know it is a code requirement, though. It is in our existing code.
Thank you.
Yep. So leading right into that, our town code currently requires water dedication to satisfy the raw water requirement. This was last updated in 2020 to an indoor only requirement. There was kind of a new tweak that we put on at that point. I wasn't here then, but we're kind of separated, allowing for an indoor only requirement to be met. And so when I talk about raw water requirement, again, that's really talking about that volume of water that we're asking a developer to dedicate to the town to meet the forever need of a development that goes in place, right? So emphasis on forever, or at least for as long as we exist as a community and a utility. We allow this indoor only requirement, acknowledging new types of development that were coming in, acknowledging that we have a lot of non-potable irrigation systems in town, and there should be a benefit to the developer that is able to meet a non-potable irrigation requirement to have that reduced overall raw water requirement. So it resulted in updating the indoor only to 0.32 acre feet per dwelling unit. And then what I'm calling, for kind of lack of a better term, a standard requirement. And by that, I just mean kind of your typical in your head that you think of a single family home with an attached yard. Around here, that's not necessarily a typical development, though. Because a lot of our development has non-potable irrigation with it. But it was just hard to come up with the right terminology there. So we are proposing to reduce that raw water requirement based fundamentally on the more comprehensive update to customer data sets that were developed as part of the rate study last year. So within that, we were able to really have a better line of sight directly into indoor usage and separate that out. Just for residential, this didn't really get into commercial. As you'll see throughout this presentation, we would still be looking at commercial and irrigation requirements to be determined at time of application, right? So we would be working with those developers and not setting a standard requirement for those situations. So we'd be asking, I'm looking to propose to reduce that indoor only requirement to 0.25 acre feet per dwelling unit. And then in turn, that would reduce the standard requirement. Again, that sort of mind's eye typical single family development to 0.5. And the majority of that reduction from a 0.58 to 0.5 is really based on that reduction in the indoor use that we were seeing. And there's just a little bit that comes from an update in some of our assumptions related to lot size, single family home footprint that sort of reduces the irrigable area. So that's where that sort of 0.01, I think, reduction in outdoor requirement would come from. And then also, as a function of the rate study that we went through as well, we are looking to consider a separate multifamily requirement. So this would be what you would think of as a traditional multifamily. So not a single family attached or a row home or town, kind of traditional townhome. What we're thinking about for this is a true like multifamily, multiple shared walls over, under, next door, suburban multifamily development. What we see in our empirical data, so our observed data, and which is on par with what is kind of common across the West and the region that was identified through that rate study as well, is that the water usage in these units tend to be about 70% of a single family unit. And that is where that 0.18 raw water requirement that we're proposing comes from. Now, again, with a multifamily requirement, do remember this is only indoor. So any outdoor irrigation that would be required would be, it's required that they have an irrigation tap. It would be assessed based on the landscaping that they're proposing to develop at that time. So that consideration would be in addition to the indoor requirements. Now, something in my way and I can't see my screen. Current water yield allocation. So currently in our municipal code, in the section that I provided here, the town accepts two forms of water, wet water for dedication. North Poudre Irrigation Company shares, so shares in the ditch company, or CBT units, Class D, CBT, Colorado Big Thompson Project units. In our code, it defines that water yield allocation for North Poudre shares as 2.4 acre feet per share. And that one CBT unit we would allocate 0.7 acre feet. Now, these are based on historical averages for these two types of water. So the historical long-term average for the Colorado Big Thompson project, it is 0.7 acre feet, which is an average. And again, the long-term average for the multiple use portion. So with the North Poudre shares, and I'm going to try and not go down the rabbit hole, but there's two types of water, and I reference that a little bit later. North Poudre owns a lot of CBT. So with a share of North Poudre comes a certain allocated amount of Colorado Big Thompson Project water too. It's called multiple use water. It's what they call it when they allocate at North Poudre. And that long-term average has been about 2.4. However, last year, they started at a 2.2 allocation, right? So we've already seen times where they were allocating less than that historical average. That's the reasoning by which I am proposing that we reduce the yields the allocation that we allocate for both shares of North Poudre and for CBT units. It is actually pretty common across the Front Range for municipalities that accept, or water providers that accept Colorado Big Thompson project units, that they accept it at actually 0.5 is fairly common. Meaning for each unit you get, we assume that it will provide us a half an acre foot in the long term in the future. And the reason for that is that we have to assume that we can get that water all of the time. So we're banking on that the project's going to yield that water every year, no matter what the hydrologic condition, no matter what the drought, no matter what the infrastructure failure, we can get a half an acre foot. So that's the reason why I'm proposing that that reduction be considered. And then also in conversely, this is kind of where I'm getting into with the kind of the Colorado Big Thompson project ownership with North Poudre. So North Poudre Irrigation Company is the single largest owner of CBT units in all the CBT project. They own 40,000 units to 10,000 shares of North Poudre. So in theory, every share of North Poudre gets you 4 units of CBT project. And if we're going to say that a unit of CBT is a half an acre foot, then 4 units in total are going to yield you 2 acre feet. And that's that sort of, and it is a conservative approach, and it is my recommendation based on, and it's actually pretty common in PAR, and I put some, or I have a table at the end actually giving some comparison municipalities. And this is just adhering to just considering long-term drought conditions, considering ongoing negotiations on the west slope, which it is our reliance on North Poudre that ties us to west slope negotiations, right? So that's our connection there. Now, current cash in lieu equivalent, the town code allows the town to accept cash in lieu of water dedication at our discretion. It is not a practice that we commonly pursue. There are definitely times where it could be of value and of preference. And I will say at this moment in time, I can't outline every single time that may be, but as we're moving towards the desire to seek water storage projects, perhaps the desire to be moving towards different kinds of water diversification, that's where we're going to need the cash in hand to be able to do that. I don't foresee that being tomorrow, but I do recommend that I recommend that I propose that we still keep this clause, if you will, of allowing us to be able to do that at our discretion. And the last time that this was updated in 2020, the staff developed, mainly Bob, developed a pretty robust mechanism to go through and consider the last several years of pricing for North Poudre shares, and then take that percent increase over the last like 3 years and then apply that as assuming another year, because the money that we would get in today, it's assuming that then we'll take that money and it'll probably be next year at best before we can purchase. So we were hedging our bets to be asking for, I don't want to say more because that's not what it is, but hedging our bets that it's going to be more expensive when we can buy it next year, because we can't turn around and immediately turn it into wet water. I'm proposing that we utilize that same approach, which does result then in a cash in lieu increase of about 20% from what equates to, and I realize this is in a couple of different units, but if we think about it in terms of, you know, our yield is in terms of acre feet, right? So I put the cash equivalent of a whole acre foot. That's not necessarily, we're not asking for an acre foot per house. It's depends on the type of development. But in an acre foot yield, so it's going from 102,800 up to 124,100. And I have that breakdown here of what that would look like per dwelling unit, different types of dwelling units. So I did provide a summary then of these changes condensed in a table so we can kind of compare where we are, this current raw water requirement, the water dedication allocation, the cash in lieu equivalent, and then compared to all 3 of those as proposed. And then finally, at the end, I did also include a summary. And one thing I realized after submitting this late, I was late too, that I didn't include the assumptions that this community comparison is based on. So this is assuming 5,000 square foot lot, 2,000 square foot home, 3 bedrooms, 2 baths, potable irrigation, right? So that's the base assumption for these varying raw water requirements and then the accompanying cash in lieu, if the community even accepts cash in lieu, which you can see here, half of them don't. They require dedication only. So this evening, what I'm looking for is if you have questions about this information or need more information to be able to provide staff with guidance on these proposed changes. I don't think that we can probably turn around this in, I didn't put a draft resolution or ordinance in here for a couple of reasons. One, we haven't had this discussion thoroughly. I wanted to make sure I had an opportunity to kind of take your guys' feedback, turn it into, modify anything as needed. And I don't think I can have that turned around by next Tuesday anyhow. So at best, it would be early April that we would come back with a draft resolution or ordinance to consider. I think it's an ordinance for this. And then also, if there's conversation and acceptance around the proposed yield changes, that is a code change as well. So I would need to talk with Dan and Patty on how we would best bring that forward and maybe wrap it into some other proposed code changes that we talked about 2 work sessions ago, I feel like, around some other chapter 13 code changes. So try and bring stuff to you all at once and not piecemeal. But so with that, I'm curious to know what questions you guys might have.
Questions, Trustee Nathan?
Yeah, so Ms. Smith, I did just want to get some clarity on the cash in lieu. That is at the town's discretion to accept money cash in lieu rather than it is not the developer's option for that. Okay, so I think it only makes sense that we keep the cash in lieu options. I mean, obviously that's kind of leaving us open in option. And I think it only makes sense to increase that requirement, especially as water, gets a little more scarce. As far as the yield allocations go, I would agree that we should reduce those yield allocations. I mean, I think you said 2.2 acre feet is what we started with this year. I think it only makes sense to bring that down to 2.0 acre feet. I don't think those numbers are probably likely to go up. What I think I'm not so clear, and maybe if you could give me some clarity on this, as far as reducing the raw water requirements for developers, I guess I'm not completely clear as to why we would want to do that, especially when yields are going down and that type of thing.
So with the kind of really robust analysis that we did with Raftellus last year, so we were able to pull in all of the commercial data residential data and commercial, but for about 5 years, and did a deep dive into that, use those usage patterns and analysis. That's how we were able to come up with the varying rate structures for residential versus multifamily, irrigation versus commercial. And in that analysis, we did see that the typical, which is not surprising, residential unit is using less water now than it did 10 years ago. That's generally speaking, passive conservation in play, right? Water efficient toilets, water efficient dishwashers, they're required as part of development in most situations now, different patterns of use. And we have seen those changes take place, and there has been just that general reduction in. And then when I take that and have gone out to look around at other communities, I do see that's pretty common. I mean, that half acre foot is where we were. I did have that kind of history in the memo packet. That half acre foot per home or per dwelling unit is where we were just a handful of years ago. And so it didn't seem like too much of a stretch. And it seemed just it's based on data that we had in-house of our observed usage patterns in town. So.
I think that answers it for me. I think as far as the rest of the board goes, I think I think the last time you mentioned we had changed this was 2020 down to the 0.032 or 0.32. I suppose I would entertain some board discussion on maybe we don't take that all the way down to 0.25. Maybe we make it something in between. I don't know. Just throwing that out there.
Yeah, I kind of had, and thank you for answering, Megan. And I appreciate that we have the information. I had similar concerns to Trustee Mason, just because, again, we're talking about providing water for forever, right, for this property. And it's good to know that, okay, we look at this and we see that, yes, we're using less water, so that's good. I do want to be cautious though about saying, hey, let's not run into this now. This does go back to, I guess the question I have is if we were to say, okay, we go down to this 0.25 or whatever acre feet or whatever the reduction is, our comprehensive plan says we go to 40,000 population. Will that reduced acre feet at 40,000 population, will we have enough water to actually support that?
Well, and I can bring a little bit of history about why we made the decisions we did in 2020. So the difference in the two is that we wanted developers to bring raw water and not the cash option. And so incentivizing or making it so that cash and lieu option is highly lucrative for the town is why there's such a difference, I guess. Out of curiosity, what is the cost of a North Peter share going today?
Last board meeting, it was 225. Last North Peter board meeting was
So back in
225.
like between 2010 and 2014, the cost of a share was like 80,000. So just to kind of give some perspective on how quickly that's changing and evolving. And you're right, our conservation and how we're using water today in the town is very different than how we were doing it years ago. So I would agree that cash and lieu should continue to be much more forward thinking so that we're encouraging developers to bring those shares with them because there are just a limited number of shares out there.
And
Yeah.
go ahead. I'm so sorry.
I would agree completely. Absolutely, Mayor Pro Tem is correct that was, I think when we made the change in 2020, there was almost a 50% subsidy on the cost of a North Peter share. So that was definitely a change. I absolutely agree that we should continue with that. And so my concern's not on the cash and lieu portion, is it's more so just reducing the dedication number itself, regardless of whether you're doing cash and lieu or otherwise. And I think that was what Trustee Mason had shared, was just reducing from, and I'm looking at the wrong page here, I apologize. From the 0.32 acre feet per dwelling unit to the 0.25, and then from the standard requirement from 0.58 to 0.5. And yeah, I like the idea of maybe we bring it down halfway and see if we still feel good, if the numbers bear out, because we're making a lot of changes. Because we may also see that with the changes to the rates where it's more focused on your usage, we may actually see our water usage go even farther down. But I'd rather bring it down a little bit, see if it's good, and then if we need to bring it down, I mean, no one's going to get mad at us about reducing the water requirement they have to bring to the down, but they will get upset with us if we have to raise it again because we went too far. So that would be my concern on reducing those. So I do like the idea of maybe if we can find a middle ground of bring it down a little bit, see how it goes over the next year, and then revisit it again.
Was that due to like shrinkage and delivery?
So I wanted to highlight this one table really quick on slide. I apparently didn't number my slides, so that's not helpful. Thank you. Where it does actually highlight the difference. And so this slide essentially, one could argue, would maybe show, well, then why, Megan, are you here to change anything if really in the end the raw water dedication stays virtually the same? If you look at the current water dedication requirement versus the proposed water dedication requirement, because of that change in yield, it essentially remains the same. There's a slight difference because we are acknowledging for the multifamily that there's a little bit less there, but otherwise the single family indoor ends up at 0.13 shares in order to meet the requirement because we're reducing that yield. And this is, I guess, in the continual pace of improvement for the utility for the town of looking at, okay, well, we have the data now to show that perhaps, and I back up, we have the data to show that water usage by residents has gone down and is continuing to go down, which is on par with all of the West. But we also have the data to show that the yield that we're asking for, the risk of it not being there is greater. So to be asking for a higher yield for those share dedications. And in the end, that becomes a wash in the total raw water requirement, as you can see from that table. It's essentially asking for it in a little bit of a different way and then covering ourselves in terms of making sure that the yield allocation that we allow is responsible to hedge our bets against the risks associated with our water supplies long-term.
Now, did you factor in the water restrictions that we've had the last 2 years? And are we projecting having water restrictions forever, ever, if we're gonna have the reduction?
I mean, with the way things are going, I would venture the water restrictions are gonna be in place for our lifetime.
But has that been factored in?
So the impact of watering restrictions would be embedded in the use data, the consumption data that was utilized as the rate study.
Yeah,
right?
you
So
said it
20,
went down,
21,
but most of,
22.
I mean, a lot of it was because of the water restrictions, correct? Did we use a comparison with what it was prior? Water
Like two
restrictions have been-
thousand six.
And I was trying to dig up that history, actually.
We started to become more active in enforcement in just the last
Yeah.
5 to 10 years, but we didn't really, the restrictions were there, but they weren't enforced.
We've still never issued a citation for watering restrictions to date.
Yeah, well, my thing would be if we brought it way down to what we're kind of projecting here. And if we do lift the water restriction sometime down the road and don't reenact it, I mean, is that going to put us in a hurting place at that point?
There are mechanisms to have in place to overcome that, right? So some mechanisms, rate structure mechanisms that are put in place is what's called budget billing or like having water budgets, which says, okay, you at time of development, your lot was turned in a 1/4 acre foot. Once you exceed a 1/4 acre foot of use in a year, the charge for that water is really high because now we have to recoup those costs and go out and buy more water because you're using more than was turned in. So there are mechanisms in place to be able to do that if sometime in the future we find that that is happening. In my professional experience, I don't anticipate that being the case.
So those are mechanisms we have now or mechanisms we could put in?
No,
place
it's
if need
mechanisms
be?
we could put in place.
Got it,
Yeah,
okay.
definitely don't have it now.
Okay.
Thank you.
So, Megan, can I just I just want to wrap my head around everything that you just said. So based on the numbers that we'd put together in 2020 was not on the rate study data. It was based on our best assumption. So we gave our best shot towards.
You want to come up here?
No, I'm not
knew
saying
I
that
was
it was,
waiting
I'm
for
not
you.
saying it was like a made up number. Bob, I'm sorry, gosh.
All
Somebody
pressure.
walk him a mic.
I know, I was wondering if I could take this off. That's just a sympathy call.
We worked with, to answer your question, trustee McDonald, we worked with the data that we had and that we had access to. And frankly, we did not have as much analytical capacity for the data we have back then. A lot of that happened when Megan and the finance department took over, handled the more recent rate study. And so that's when we really collected quite a bit more data. So it wasn't just the data that happened, in those intervening 2 years. It was really having a better grasp of the data that we had. There's no other way to say it.
Okay, so this is like a much better accurate number based off of data that's been collected.
Yeah, I think it's a more refined number for sure.
Okay. That was it. I was just trying to understand the differences. Back then it was closer to an assumption and this is much more refined.
Yeah, it was more than an assumption, but yeah, this is.
Back then it was based off of the data we had. Now we have more data.
But more better data?
More better. Mo better.
Fair to say, yes. It is Mo better.
Trustee Teagues.
I do. I have 2 questions which could bring on more depending. So the community comparisons that you gave, Meade, Frederick, Windsor, and Berthoud, it says that they do a cash inlay equivalent. So, but they also, do they run off of North Pooter or do they get Greeley water?
There are a variety of sources.
Okay, so in Severance, Timnath, Johnstown, Firestone, do we know what water they run off of, North Pooter or Greeley?
Neither. So Severance and Severance is served by Northweld County to my Northweld County Water District. Firestone, I believe, is St. Frank. I mean, I can get that to you. I don't want to rattle
That
off.
would be some
So I can forward that to you.
information
So
that,
most of them are served by water districts that accept a variety of other ditch company rights as well as CBT rights or CBT units.
they are. And that was one thing that leads to that next question.
Some of these accept only CBT.
Got it. And that's what
Oh.
kind of transitioned to my next question is are we kind of shooting ourselves in the foot when we look at cash in lieu equivalent with some of these municipalities? It would be nice to know if they are involved in Greeley water because there is an excess amount of those available compared to North Poudre. My other concern is the cash in lieu that we're asking, and I could have missed this when you explained it, is the asking price right now was the 224,500 for 1 acre foot, 224,500 in 2022 for an acre foot of North Poudre.
So
That's
one share.
One share, and one share is,
Depends on the year and the hydrologic conditions.
got it. So it's not guaranteed that it will produce 0.25
It would-
per unit.
Right, like last year, we got 2.2,
Mm-hmm.
and we.
2.3.
We're getting 2.5. Correct?
Just, yeah, long-term average is 2.4 acre feet for multiple use portion. And the water that we currently use through North Poudre is not part of these shares. It's part of our lease agreement that we have. So there's
Right.
additional.
But that's what I'm saying is when you look at the cash and lieu equivalent, what we're asking, and this could be what I'm missing is the amount too little to compensate for water down the road?
So my understanding, and Bob or Megan, you can jump in if I get it wrong, is our cash in lieu, don't look at that as based on, is it high or low compared to other people's? Because our cash in lieu is directly tied to what is the current price of shares of North Poudre multiplied by a multiplier that looks at what has it done over the last, I think it's 3 years. So basically, if the price of North Poudre currently is 225 for one share, and you were bringing, let's just say you were bringing one share, forget it's a portion or whatever, say you need to dedicate one share, you would not be paying us 225, you'd be paying us 225 also times that multiplier for based on the past 3 years, which may be 240 or whatever it is. And so what's here is just the breakdown of that share. When you look at the acre feet that would be required for a single family home, that's where you get the 61,960. But in terms of if you had to bring a full share of North Poudre that we were doing cash in lieu, you are guaranteed to pay us more than the current price of that share, because we understand we cannot purchase it till some unknown point in the future. Is that?
Yeah, that was very good. Got it.
Go for it.
All right, so I specifically in the multifamily, I just want to clarify this to make sure it's understood by everybody, but the proposed multifamily requirements, the reduced multifamily requirements are based on inside use only. So if that proposed development did have pot irrigation outside, that would be a case by case basis, and there would be a calculation that would have requirements based off of their landscaping needs.
Exactly.
Okay. But with the understanding that that's like one holistic landscaping need, not one per each multi-family unit living there.
Mhm.
Okay, so I wanted to clarify that for sure. So for example, if there was a non-pot development for multifamily, they would really just be looking at the 0.18 requirement
Correct.
as proposed here. Okay, so I want to make sure that that was clear because it's not that we're not requiring any landscaping requirements for multifamily units. That may have been very obvious to everyone else, but I wanted to make sure that we clarify that that's case by case for potable landscape needs. The other one I have is there's been a general theme from our roundtables for water rates. And the general theme has been pay for what you use. You pay your share. Nobody else is required to pay for anybody else. You pay what you use. And the information that we have says how much people use. So within the same theme and vision that we've been provided through those very valuable roundtables, my understanding is if we have the factual information of how much our households are actually using, that should be in our equation. We should not bump it or say that they might use more, especially if that's the way that we approach water rates, uses, fees, anything like that. If we know how much you're using, especially based on a 5-year estimate, then that's the value I think that we should be using. What I do appreciate though, is that we do have the option to put in some safe proofing is within the yields. Because that is really where we have a huge variable. We don't know what's going to happen. So what we do know is how much household use. So I think we should use that in our equation. What we don't know is the yields. To be safe, we can adjust those yields as presented to ensure that we are safe proofing, future proofing for what could happen. We don't know, but we're being safe in that variable of this equation. And I think that's where it should be. So I agree with that. Regarding and I'm really glad you brought this to attention because, both of those items are going down. Requirements were going down and yields were going down. And I don't think that people understand that those are different sides of the equation. So therefore resulting in pretty much the same proposed water dedication. So when both of those values go down, but they're on different sides of the equation, that's what the result might be. And I think that again is making us fair, yet being safe for the future. So I appreciate both of those. The other thing about the cash in lieu, and this kind of has to equate to all of these variables because there's 3 variables we're talking about. We're talking about requirements, we're talking about yields, we're talking about cost, right? For in lieu. All 3 of those items rely on data that's available or that we've recently had through studies. I'm curious that as we go forward in the future, as we kind of design this as to, if the requirements are always based on a conservative 5-year estimate, then that is a value and equation that we would know to use going forward. There's no reason to debate that. We use 5 years of data to determine our requirements. If the yields are based on historical yields that we're seeing, that is a valuable data point that we can use. And then if we understand that we are using a safe estimate based on that. So that's data we have and can move forward with. And then the costs in lieu, we know what they've been selling shares for. So again, this is data that's available. So long as we understand the theme and method as to what we're charging, as this changes throughout the future, I think we have a plan moving forward as to how to make this fair and safe for our community. And I think all these considerations contribute to that. Should we readdress it constantly or yearly or whatever the case may be? Absolutely. But I think if we use these methods, I think that we can confidently say, we're doing what's safe for our community, we're planning for the future, and we're fair. And I think with all 3 of those things as proposed, we are very defensible in what we're asking and charging. And I feel like I could stand behind that and say this is fair and what's right for our town, and it keeps us protected in the future.
Yeah, I mean, this all makes sense to me. I mean, we're having development pay its own way. still, even though we're lowering the number, we're yielding, the yield's changing and the amount that we're using is changing. And so why would we ask a developer to pay more than what they're actually using or what is going to be used in the future? I mean, it's a common trend with home building now to zero-scape. I mean, it's a fast growing trend, and it's catching on a lot here in Colorado. So we're just going to continue to see yields go down per household, per, things of that nature. And especially in multifamily units, we're seeing more of that as well. Everything that was presented here makes sense to me. I don't see anything that would tell me that this is a bad idea by any means. We're protecting ourselves across the board, and we're setting ourselves up, especially with the cash in lieu, to where we could hedge bets and maybe diversify down the road or tie into a pipeline or whatever the case may be that's coming. So yeah, that's where I'm at with it.
One last comment from my perspective versus 3 years ago when we made these choices is, since then, we invested from the perspective of a board in doing a study, a significant study, so that we could understand the usages better, which definitely related into the fees, for all of our consumers necessarily. So the reason why we know more now is because we asked to study that then. And that's why we have the information we have now to make more fair, better choices for the future. So when it's like, why didn't we have data then? Well, why we didn't have data then. That's why we asked for it. Now we have it. What are we going to do with it?
So I had two things. One was the data for the multifamily use, because I know you're talking about this, not talking about like townhomes, but more like I don't know what that was that based off of actual multifamily that we have here in Wellington, or is that based on like regional data, or I don't know what all we have currently.
It was both,
Okay.
but keeping in mind, and it was, so we have a pretty small data set sample size for that kind of traditional multifamily, multiple shared walls, multifamily. So we did verify that against, trends across the region specific to Colorado, and it aligned very closely with, it was actually a little bit under that 70%, but it's right at, essentially it was using pretty much 70% of what a typical single family utilized
Okay, and that's per unit.
per unit. Yeah.
Got it. Okay. So for example, if I have a fourplex, you're not dedicating 0.18, but you're dedicating that 0.18 for each of those four units that you have.
Exactly.
Okay.
Plus whatever irrigation requirement there
Plus
would be.
irrigation. Okay. The second question, and this is part of a much longer discussion, but the other thing too, we talk about the proposed acre feet and water that's dedicated, but you did make the point, we've talked about this before, but the water that we provide currently does not come from the so we get a share of North Poudre, we can't actually turn that into potable water. And that's the other concern I have, or does that factor in when we're saying, yes, this share is worth this much and gives us this many acre feet, but at the moment we don't actually know how many acre feet we can get because we cannot turn that share into potable water.
And so in the 2023 budget, there was, the board thankfully approved, or I think you approved, dollars for water resources evaluation. We have begun some of that effort. There will be some additional information that as part of the executive session executive session this evening.
Okay.
But there are plans, discussions, conversations, and planning ongoing to be able to utilize those shares via Reservoir 3 in some shape or form. So
Okay.
as well as CBT. I mean, currently we don't have a carriage agreement in place with North Poudre to move CBT water through their system and get it to Reservoir 3, and those discussions are ongoing. So that is part of the planning effort.
So do you feel confident, obviously there's a lot that's going to have to happen before those agreements can actually come to place, but do you feel confident that when we're putting in these numbers with the, obviously I understand the reduction in the yield, that's great, but in reducing that, even if we look at, hey, we don't get the greatest of agreements in place, even with a poor agreement, do we feel comfortable with these proposed numbers? Let's just say that we get an agreement we really, really don't like, and it's really not favorable to us. are we gonna be okay with our 0.25, 0.5, and 0.18?
Those are the volumes of, I support that those are the volumes of water that are needed to support a residential unit in these varying shapes into the future.
Okay.
Now, where that water comes from, right, that could be a different conversation.
Okay.
But those volumes of water, yes, I do stand behind.
Okay, thank you.
Correction? I'm good with it.
Okay.
Yeah, okay.
Okay,
Rock
so
and
we
roll
have-
with it and bring it back sometime. April
Sure.
time.
Yep, we'll bring it back with the rest of the chapter 13
Perfect.
Perfect.
next month.
Next month, yeah.
Sorry.
Hey, Bob, thank you for being a
I
trooper.
really am. Thank you.
Sorry that your pretend did that.
Sorry.
I don't feel like moving, so just
Okay.
just ignore me.
All right, I'm gonna think about the best, so that's good. Moving on to the next one. Okay. So I'm gonna think about the best way to do this, which is I don't have her PowerPoint, but I have.
Oh, you should have the packet.
I have the packet, so I will just share, I'll share that.
Packet.
Let me get to that in the packet.
If it was a PDF, it would page 47, not the other truck.
Yeah.
Or-
There we go. Am I still on Zoom? There's Zoom. Am I no longer? Oh, no, here I am. Sorry. All right, let me blow this up a little bit. And then you can imagine me with long blonde hair. Long straight blonde hair like I always wanted. Okay. We're gonna talk this evening about proposed outdoor watering restrictions. I did work with Hallie to develop this, so I'm gonna do my best to do as good of a job as she would have done. As some background, this may be the first time that some of you have seen this presentation or a version of it for our new board members or newer board members. You're not new at this point. You're old hats now, but so just as some background, about half of our water customers, as I talked about before, use treated water for irrigation. The flip side of that is the other half uses non-potable, which is a great statistic to have for a community of our size, by the way. Yeah. So half of our water customers use treated water for irrigation, and just those half, that irrigation demand accounts for about half of treated water demand during the summer. So imagine if we had the other half of our customers on treated water. Now, as a reminder also, our current plant expansion that we are undergoing right now and will not be complete for final completion until late summer of 24. We'll be increasing that treated water capacity of our conventional plant. So at our large water, our Reservoir 3 site from 2 million gallons per day up to 4.2 million gallons per day. And this existing plant, including our nanofiltration facility at our Wilson Wells, are going to be pushed really hard both this summer and next summer in order to be able to keep up with that demand that we've seen. For those who were on the board or keenly tuned in 2020, which he might still have nightmares about. I wasn't here then. We pushed that really hard and managed to make more water than was originally designed for from that plant. That included overnight stays at the water facility for a lot of staff. So as a reminder, this is a graph that you've seen before in part of our utility reports that we're producing for the board. This shows the monthly production as well as annual production down at the bottom for the conventional and nano plants mainly. And you can see that kind of green bar there that spikes up higher, that was 2020. We have seen some reduction from that for monthly usage, thankfully. But as we scroll into this next, oh no, so I'll go back up. Sorry, you can tell I'm doing my best. So some of those operational risks that we put ourselves into by trying to push those plants as hard as we can, as they're slowly falling apart around our ears, is that we experience pushing the plants beyond their maximum design production. So as you can see in July of 2020, we had a single day max production rate of 2.5 million gallons. In June of 2021, and also context 2020, hot dry, trace precipitation, if any. And everybody was home. 2021, a little bit back to normal, not as abnormally dry. That peak day production did come down, and it was in mid to late June, which is actually more typical for peak production at 2.2. And again, in 2022, we saw that our peak production at the same and roughly the same time frame. So we have backed off of that, and I think a lot of that has to do with normal course of daily life, not everyone being at home all of the time, going back to business and everything else. Now, we have been suffering from, we do run the risk of suffering from more aging equipment and infrastructure failures. We have had pumps fail, we have had VFDs fail. We are doing our best to be very responsible with the dollars that we spend on replacing equipment that might not be in use in 18 to 24 short months, 18 months really from now. So, but at that same time, we have to keep producing. So we also have kind of right now really a lack of redundancy in our system. So if we do have those equipment failures, that's scary. And then secondly, the risk that we run by waiting, by looking to put restrictions in place as we have done the last couple of years, kind of in advance of any of those peak demands, is that we're able to get ahead of the communication, and we're not trying to play catch up. So it's a proactive stance, right? Instead of reactive and surprising people later in the game. We're able to put that, in social media and our bill inserts at appropriate time and that sort of thing. Now, this is just a graph some of you might not have seen. It's been recently updated with our most recent 2022 data, and then also updating that, hence the trajectory of our expected future peak demands, which is really what this graph is showing. It's this historic max day total demands and the projected potential projected increase in those peak day demands. We're hovering really close to that solid red line at the bottom. That dashed red line, that shows our total current treatment capacity at our conventional facility and our nano facility with our microfiltration unit included in that. And as a reminder, our microfiltration unit can make potable water that exceeds water quality standards, but it doesn't do a very good job against taste and odor issues. So it's not something that we are keen to utilize if we don't have to. It creates turmoil and disgruntled customers. So, but it is there. It is ready to turn on at a moment's notice if it needs to be. It does produce water quality that exceeds water quality standards and regulations. But it doesn't catch the algae that creates the taste and odor issues. Oh. So we are, the water efficiency programs that we do currently have in place, or we are planning for this year. We did sign up this year to utilize Resource Central's Garden in a Box program. It's been pretty successful so far. We have, as of the date of the creation of this, and I haven't updated, we'll get an updated one tomorrow, I think, but we've had 15 of the 25 boxes already claimed by our residents. We're also doing free irrigation audits again this year and expanding that opportunity to non-residential customers as well, looking to do a little bit of targeted outreach to some of our potable water HOAs or larger businesses with potable water. We don't have all the money in the world to do it, and they're charged at a little different rate than a residential irrigation audit. But given the new rate structure, Hallie and I really wanted to try and tackle the ability to provide some help, relief, education to some of our, I guess technically non-residential, though HOAs feel very residential. So, but they are a commercial customer. The standard education and engagement opportunities that we have done in years past, including educational water bill stuffers, inserts, events, and promotions. We do have an engagement survey that's going out or has gone out. It's out right now for the water conservation program. Okay. And then we do have indoor programs. If you go into the municipal services building today, you can grab a toilet tab to leak test any of your toilets in your home. Hallie is still running our shower head exchange program that we have through our coordination with Northern Water. So continuing all of those historical efforts and adding a couple new ones this year on pretty low cost. So included in this packet as well is the historical resolution that the board has seen in the past. I don't think anything was changed on that. It was more to provide you with some an opportunity to review the language of what it would look like should there be direction provided to go ahead and move forward with bringing watering restrictions resolution forward soon. So with that, I would like to open it up to discussion and your questions and see if I can clarify anything for you.
Trustee Gator. Thank you for bringing this to a work session. I really appreciate so we can have discussion on it and then we can decide what we're going to do. So I completely understand the idea behind what we're trying to do, conserving water. I support trying to keep the plant up and running. Where I run into my request is not saying let's not do watering restrictions. I'm not a fan of the heavy hand of government. We're here to force you to do this. What I'd like to see us try, and I understand we've never actually fined anyone, so to some level, yes, we aren't, is we've not really said we're going to go the full force of communicating this out, treating this like it's mandatory, but instead of saying, hey, saying we want you, the community, to help us, and asking the community to say, we want to partner you, we want you to partner with us so we can all keep our plant running versus here's the stick that I can hit you over the head with if you disobey me. And I understand we're trying to keep the plant running. So that's what I would like to see us find a way to do that, to say, let's partner together with community versus we're here with the stick if you disobey. I understand we haven't used the stick, but we are every year since 2020, we have come in with a, here is the fine stick that I can hit you with if you don't follow these rules versus here's the rules we need everyone to follow. We're asking you as members of the community, please, all of us work together on this. And try that, see if our community will actually respond to that. And if they won't, and they're like, forget you, we're going to wreck your water plant. Okay, maybe we do have to go with the stick, but we've never, I understand there's been, there's a word I'm looking for, not managed, optional water restrictions in the past, but it's never been communicated like we have been communicating the last 3 years. It's never been like, this is a big deal, we need to all work together. It's just been like a, hey, if you can do this, great. And it's just kind of been there. So that's what I would like to see us try to do is, again, can we work alongside the community and try that? And again, if you look at the numbers, the good news is they have been much reduced from the prior years. We're not seeing the numbers we saw in 2020. And even in a lot of cases, as you look at this, we're not even seeing the numbers that we saw in 2019. In a lot of cases, those numbers of usage where production is actually lower than it has been, which is good. Even though we had a lot of growth in 2019, we had a lot of growth in 2020. In a lot of cases, we're still saying at level or in some cases lower in terms of usage. So that's kind of my thought process. I understand the need. And I'm not saying, oh, just don't talk about, I'm saying let's communicate it out, but can we try to do this as let's work together with the community, invite them in as partners versus being the guy on the block that'll take you out if you don't do what we say. So that's kind of my thought. Other than that, I know sometime if we could try to make adjustments on the days to maybe make that a little simpler, because it can get, I know for some people have automated systems, it's no big deal, but there are also people that are putting sprinklers out. I'm one of them that I put the sprinkler out on the days. And if for whatever reason I'm gone on a Thursday and I can't, that's my day to water. And it's like, then my grass is dying because I can't go back and water on a Friday. I don't know if we could try to work that out to where it's a couple of days or something like that. If there's an easier, I know part of it is trying to plan the plant accordingly. So I don't know if that's possible, but that would be my only other request is that there's some way to adjust the days so it gives people more flexibility, or maybe they can water twice a week and these are your days for odd or these are your days for even. But I understand that might not help the operators if there's more days. But those are my 2 points that I'd like to bring up.
So I know that there is protections for homeowners related to HOAs when there is a mandatory watering restriction set in place by your municipality, does that help protect homeowners whose yards are dying because you can only water them once or twice? Is that a state ordinance that protects them, or is that a municipal ordinance that protects them, that aids in protecting them from the HOA fining them?
That's the state that allows that if the municipality has a watering restriction in place, the HOA cannot fine a
Got it.
resident for not keeping their grass up to their HOA standard.
So if we don't set a mandatory something in place, are our residents protected from receiving those fines?
No.
I would need to look into the detail around mandatory versus voluntary.
Because
That's a good question. And I don't have the answer off the top of my head. If
And
I don't
I'm-
know if voluntary
Based off of what I know,
restrictions.
I'd say no, they're not protected.
And I'm interested in exploring, but I want to make sure we're protecting residents. If we're saying it's optional, then an HOA can see that as this is optional. And then our residents aren't protected from receiving fines when all they're doing is trying to do what the town is telling them to do in the first place. So I just want to make sure that we're covering our base on that before I make a decision to explore voluntary versus mandatory. That would be something I ask.
Yeah, I mean, I understand where trustee Gator's coming from without a doubt. I'm also one of those hard-headed fools that unless somebody puts a mandatory restriction on me, I'm not gonna really follow it. And even when they do, if they're not enforcing it, I'm probably not gonna follow it. I mean, that's
On it.
so check the public record. I've been at the podium. So, I mean, things like this are necessary for people like me. And there's a lot of me's in this town, I would believe, with that frame of mind. So I think this mandatory restriction, I mean, it is always in the back of your mind when you're out there watering on the day that's not yours or whatever the case may be. So it does have an effect. And I think that it's valuable for us as a community with where we're at with our plant and where we're heading. And that was a great point on the HOA. I mean, we'll need to check with Dan on that, or
Dan, I got a text message from Dan. He will be looking into it and reporting out. Thank you.
that'd be valuable too, because the last thing I want to do is for them to have nothing to back up getting fined.
Right.
Yeah, that's where I'm at.
I have a few comments. The significant amount of water use, half of it through the summer months, we have so much that we could potentially be controlling and that people need to be aware of. So this is a matter of public safety. If it were to fail, we are not providing water to our customers, to our users, to our community. This is not an inconvenience. This is a matter of public safety in my mind. And the purpose of the restrictions for people like the mayor or for anybody else is to have a defined collective purpose and it's official. So even if that's what it takes for you to follow it, it's also what it takes for people to understand that it's important. So even if they do follow directions better. But our responsibility here is to provide water. Like that's our utility. That's what we're supposed to do. So if there's something that we know that risks that and we don't do our best effort to control it, then we are not serving our community. So that's where I stand on it. Also, I want everybody to know that within the watering restrictions, there's absolutely no reason why you can't have a nice green lawn. People keep thinking that your lawn will die because of the restrictions. That's absolutely not the case. There are so many opportunities with appropriate fertilization and aeration that you will have a beautiful lawn regardless of only watering twice a week during specific hours of the day. There is no reason why anybody should have a dead lawn. That's not what will happen under this restriction if people are responsibly taking care of their yards. So I want that to be a point too. This is not saying your yard will die. That is not the case. So there's ways to do that. And there's obviously tools that we're providing to help people understand that better. The other piece that was mentioned a couple times about HOAs is we have an amazing landscape design guide right now that was done throughout the process, the comprehensive guide, which provides native plants, great techniques, all kinds of suggestions, which if given to an HOA and they were accepting, could very easily be adopted as here are our new landscape designs that follow all these best practices. So I think we have an opportunity for education with HOAs to say, hey, you may have current landscaping guidelines right now. The town has done all this effort to put together best practices, and it's in this beautiful guide with wonderful pictures and links and resources. If you guys were to want to adopt this instead, here's this amazing document that's available for free on our website. That would be a great opportunity for education for HOAs. The other thing is we have very specific HOAs that are large and have pot water irrigation. I think we might have an opportunity for education within those HOAs in particular. Like if they are doing a meeting, that potentially we could come and just let them know everybody has the exact same irrigation control. This is how you change the times and dates. This is how you do it and what our recommendations would be. Bam, the entire neighborhood would be within the requirements and everybody would still have green lawns. So, I mean, there's so many opportunities, more and above and beyond the many great tools that we're providing. I think we can go a little bit extra. And some HOAs have reached out to me and I provided links to our landscaping guide. And I recommended maybe taking this to their HOA board and seeing maybe we should adopt this and save each other having to find each other or report out on each other. And then everybody has the tools and methods to be successful. So in my mind, this has to be mandatory. They don't say recommended speed through school zones is 20 miles per hour. They don't make recommendations, just let people know it's recommended not to mow down kids. No, they have to have flashing lights with intense fines, double fines to say, no, we're serious. This is actually where you need to be safe. So that's the policy I would follow for this because it is also a matter of public safety.
I think if you're gonna have restrictions, you need to enforce them. Because, you know, I see people all the time disregarding it. And, but if we're not gonna enforce it, why don't we do voluntary then? I mean, like over in my edition that I live in, it's HOA regulated. It's amazing how many dead lawns we got in our neighborhood. This has given them an excuse not to maintain their property. And the HOA has no teeth to be able to enforce anything because of what the state requirements. So I think we either need to do one or the other. I would love to see the state come in and say, you know, the HOA can at least enforce something as far as maintaining your property, because that's only fair for the rest of the residents in the neighborhood. And, you know, and by doing it mandatory, you give these people an out. And again, like over in my edition, I bet you probably 1 out of 10, you got dead lawns. And is that fair for everybody else? You know, we've got a lot of money invested in our place. And, you know, it takes away from property values too. I mean, maybe that's a little selfish in it, but again, you know, you do take pride in your ownership and that's what you want. And, you know, guess what? One of the biggest restrictions that we got right now for enforcement is our cost. I mean, when you start paying $300, $400, $500 for irrigation in the summertime, people are not, even mayor is not going to overwater his yard. So, I mean, again, I think we got good stuff in position. Maybe we should look at voluntary initially, but make sure that we can turn on a dime if we do run into a situation. You know, we have done a lot of things in this community for water conservation, and I think that's great what we've done. But again, and I think with Trustee Gator on this, you know, we need to you know, give our people a little bit of respect too on that they're smart enough to regulate and do what's right for the community.
Yeah, I mean, I think we give the people, by not heavy-handedly enforcing it, we're kind of giving them, it's voluntary, but it's written down as mandatory for the people like me that like need that word. to tell them, hey, knock it off.
But by doing that, you've given people in the HOAs a reason just to let everything go to hell. And that's what we got to be concerned about too.
Yeah,
Because if you had somebody right next door to you, I've got great neighbors in my neighborhood.
Yeah.
But I mean, you walk a few blocks over and you got some problems.
right.
And if you had somebody like that right next to you, would you really appreciate it? So,
I live in a non-HOA, so I deal with a lot of different stuff.
right, but again, but I don't.
Yeah, right. So
Okay.
I did want to, and I would make, one point I agree. So to be clear, I am not in support of mandatory. Now, as Sam talked about, the board makes a decision. That's the decision we make. So if that's what we do, we do. But I would agree with Dave.
Yeah,
I don't think we should be fining people for using their water. But if we are going to make it mandatory, why is it mandatory for not fining people? Like, it's just like, if we're seriously just not doing anything about it, it's like, if you're actually gonna take the step and say, I'm going to, here's the stick that I'm gonna hit you with, but you never, why? Why
you do
even
the
tell them?
3-strike rule.
So so that was my thought. If you're gonna go with mandatory, you should actually enforce it.
You know, to make the statement earlier that we don't actually enforce it, I guess, is not necessarily true. Because I've received code enforcement complaints.
But not for watering, right?
Mm,
And we do.
I've
and
never
there's-
gotten one.
There's
Not
door
for,
hangers that go out. We
yeah,
just
but-
haven't issued a fine.
Right.
We put lots of,
my landlord, I believe, did,
Letters
because
and
I left
stuff
my
out.
hose running once.
Oh, okay.
So and we have gone typically through, and we've talked about this to educate, because a lot of times people don't know if they're new residents, they've just moved here, whatever, or they are just caught up in life. And sometimes people just forget. So we do go through the process of more education. We put the door hanger out there. If somebody's out there and they're watering the lawn on the day that's not theirs, and somebody sees them, code enforcement, somebody from Bob's department, Megan's department, they'll stop and just say, hey, just want to let you know, and give that education. We are talking internally about how to handle enforcement if this is the direction the Board of Trustees go. I didn't want to put a lot of time and effort into that until we knew how this was going to go, because I've heard you for 2 years in a row now that we don't enforce it. So if this is the direction, if there is mandatory watering restrictions, then we will talk internally and move forward with how we can make sure that happens, that there is some enforcement, if that is the direction of the trustees.
Yeah. Yeah, one more, and then let's come up with a direction.
Sorry. So I know that it was stressed about meeting with homeowners associations and discussing how they can use the adopted landscaping guidelines that the town has produced. The only issue, and this is something I had brought up previously in a meeting, was the discussion of how difficult it is to change HOA documents. So, and in order for you to set in a new ordinance in your HOA, it's an amendment to a document, and it's tens of thousands of dollars to change that amendment. The discussion I had when I was president on my homeowners association, we had the same discussion about changing some things, and it was explained to us it can be extremely costly to do so. So maybe in looking at that, if there is something additional that we can do or work with or pair with the homeowners, if we are going to introduce the new landscaping with previous HOA companies, if there's a way to support them in looking at that transition, I don't know what that would look like, because we can't financially help
Trustee Keats,
HOAs.
but is that really like related to what we're talking about right now?
Absolutely, because if we're
As
looking.
in how to move forward?
Well, it could be a part of how we move forward
Okay.
with supporting
Okay,
the areas. But that was my main thing, is I know that it can be costly for homeowners associations. So how do we assist with that?
okay. Direction?
Well, I guess I'll give my opinion since everybody else did.
You haven't
Uh,
spoken.
So honestly, I like it the way it's proposed. I understand that this board has had some issues with language, especially recently. And I do agree with Trustee Gator that I would very much like to see this go back to being 100% voluntary. However, I think we need to get through the next 18 months and make sure that we're being truly responsible about this, because if something does happen to one of those plants, we're going to have a real problem. And I do not want to see these get pushed over capacity in the summertime. So I think it's responsible that we use the mandatory language. I do not want to give the direction that we should be fining folks.
But do you want to
But-
protect the plants?
I want to protect the plants. That's the name of the game, right? 18 months. That's all we need. And then we can
Not
come back
following
and
it, do
change
it.
this to voluntary.
If they're not following it, do we enforce it?
N-
To protect the
I-
plants?
I would like to see an enforcement plan,
I would
Mhm.
too, if we're gonna do it. Okay.
because that,
Okay.
sorry, are you done?
Well, we were, you know, we were just having a conversation.
Because
but it's
I
cool.
just want to give like
Yeah.
my 30-second perspective,
Go
my
for it.
bullet points. So we've worked really hard to re-educate the community on using our water more responsibly. So I wholeheartedly support the mandatory watering restrictions. What I do not like is calling on neighbor all of the time and that becoming the enforcement process. So I agree. I would like to see, I think that you brought up a great point that by raising the water rates and creating the tier structure, we have created a way that fines our citizens
And I've got a
for
question for you.
overusing the water. So once our water treatment plant is online and we're not putting that resource
Sure.
at risk,
Sure.
then we can lift that mandatory piece.
Sure.
But I think until the treatment plant is done, we have to keep that mandatory piece in place.
What
But
about
I want to see a
enforcement?
code enforcement plan.
Okay.
I would like to see it introduced as mandatory, absolutely. And then just on the communication side, since we received information on those efforts, I'd love to see a lot more yard signs. That was the request from people of the yard signs. Those were the most visible and present in most of the neighborhoods.
What about an enforcement plan?
Yeah, but I also very much agree with the discretion of educating. Someone leaves their hose on, they shouldn't be fined. They should be educated and helped. If someone's negligent and actively going against the mandatory restrictions, they should be penalized.
Yeah.
And if they're repeatedly showing that, then they are making a choice. So, and if they've already been educated, I mean, there you go. There's, so there should be enforcement. I agree, but I appreciate the grace of the town with education and making good relationships with their customers. I think that's first and foremost, the most important thing is that we're educating and having that relationship. But then, if we're seeing people who are on purpose doing this, they need to be fined. And that money should go back into education. Full circle. Yeah, so I would like to see a mandatory.
So as I said earlier, again, on principle, I have issue with a lot of great points to raise. So I would be opposed to mandatory. Again, that's the board size. So what we decide, I would absolutely agree. If we're going to make it mandatory, I think there absolutely has to be an enforcement plan. And so we can task staff to put something together. So when it is brought back to us for a vote, that we can actually have discussion on what that enforcement plan should look like. And then if it is approved at that time, it can be with whatever the appropriate enforcement plan is. Okay.
I asked for this last year, so beggars can't be choosers. I absolutely agree with the enforcement plan
Yep.
of action.
Trustee Wiegand?
Ditto.
Perfect. Yeah, I agree with it too. I'm voting against myself here.
Well, the other thing, thank you, everyone, staff, board. This is one of the biggest frustrations I had in prior years. We weren't able to have this conversation before being asked to vote on it. So thank you very much for allowing me to at least have, regardless of whether what I want to have happen happens, I like that we're able to have the dialogue and discussion. So thank you.
Cool. Got direction?
We're there,
Gravy.
mandatory resolution, and we will come up with an enforcement plan to do that.
Great, great. Are you doing our planning calendar too?
No, and that's just in there, so that will, the plan is to always have that in your work session packets, just it's more for public perception. So they know what topics the Board of Trustees could be
Okay.
talking about. The document could change, or those topics could change without notice, depending on, how things flesh out, but this will always be in your work session packet once a month.
Okay, perfect.
has some exciting events on the back.
Thanks, Bob.
So
Thanks,
don't miss
Megan.
out on that.
Appreciate it. Okay. So now I will call. Let's take a recess.
Like that call.
Absolutely. All right, I now call to order the March 21st, 2023 meeting of the Wellington Board of Trustees, time being 3:21, or I was reading the date. 9:07 PM. Please rise for pledge of allegiance. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. May I get a roll call, please?
Certainly. Good evening. Trustee Wiegand.
Here.
Trustee Teets.
Here.
Trustee Mason.
Here.
Trustee Daly.
Present.
Trustee Gator.
Here.
Mayor Pro Tem McDonald.
Here.
Mayor Shosse.
Here.
Thank you.
Are there any amendments to the agenda? No. Are there any conflicts to the agenda? No. Perfect. We'll now move on to item B1, public comment. The individual wishing to speak, please state your name for public record. You'll have 3 minutes to speak.
Dawn Peacock. Okay, last Tuesday revealed an ugly bias in Wellington. That the town not only doesn't promote the concept of diversity, I'm not talking about legislatively, but as a dialogue in the community, but it actively went out of its way to even allow the use of the word in a national survey that'll be included in the town survey. It was reported that the standard selection of the survey, part of the survey, had over 140 lines of items to be ranked or scored, and that some form of the word diverse only existed on 3 of the 140 lines. I did verify that 3 out of more than 140 lines use that word or some derivative of it. Over 30 minutes was spent on eliminating or changing 3 words and a section of demographic data, allowing our residents to identify their gender appropriately. Quick science fact, there are more than XX and XY chromosomal gender identities. There's also XXY, XYY, and X. 2% of people are intersex. Not statistically significant. Here are other things that represent 2% that I'm going to guess you might count as statistically significant. 2% of people have green eyes. 2% of people have red hair. 2% of the population of the planet are Russians. Is that 2% insignificant? Do we not care that 2% is there? Because I'm pretty sure everyone has an opinion on one side or another about Russia right now. And the queer community is far higher than 2% of the population. Everyone is significant and everyone deserves representation, even the crazy redheads, maybe. Another slap in the face was the request to leave out diversity, but to keep homeless, elderly, and disabled in, because we actually have that here in Wellington. Does that mean that we don't have the other types of diversity in town, or that we just don't want to acknowledge it? Diversity is just a word. It's a word that includes differences in racial, ethnic, socioeconomic, cultural, lifestyle experiences and interests. We're good with cherry picking from that definition, but apparently not using the entire word. Children are taught that some books present windows and others present mirrors. Windows allow us to look into others' experiences, and mirrors let us see ourselves. Let's have more windows, but let's also let everyone have a mirror in this town. And for those of you that may be watching on Zoom or YouTube that feel that you're part of that underrepresented diversity, just know that we do see you and we have your back.
Thank you.
Christine Gator, I want to talk about the suicide rates, attempted suicide that has been brought up a lot. Although the attempted suicide rates for teenagers are high, thankfully, the actual suicide rate for them is really low, 13 and 100,000 a year. That's 0.01%. Now compare that to veterans, where it is 17 a day. So big comparison. We're talking about what group is most impacted. I would say it's the veterans. Some people compare, unfortunately, apples to oranges. They compare suicidal teenagers that are trans to the general teenage population. Whereas there's a study done that compares apples to apples. The suicidal rate, suicidal teenagers that are trans compared to suicidal teenagers that are not trans. Therefore, the only difference is the trans factor. And the study showed that there was no difference. So trans is not a factor that causes suicidal attempts. And so the things that gathering places, gender affirming, those are not solutions that will solve the problem. The problem is depression. And another study showed the people with the lowest depression rate are those that regularly attend church. Because churches preach the gospel of hope. What better solution is there to depression than hope? The gospel of hope that God loves you so much that he sent his only begotten son to die for your sins, to be buried and to rise again 3 days later, according to the scriptures, to conquer sin and death for you so that you can have hope of eternal life. That's the message that churches preach, the message of the gospel of Jesus Christ. That's all I wanted to share. Thank you so much.
Thank you. All right, on to action item. First item and our only item, I'll tell you in executive session, is going to be the advisory board appreciation dinner presented by Trustee Teets.
So I will make this as easy and clear as possible. I had volunteered to help with planning this dinner. I did reach out to Avuncular Bob's T-Bar Inn to secure a place to be able to host the appreciation dinner, April 26th, 6 p.m. So if someone wants to put that on your calendars, the cost did increase $2. Unfortunately, it's $28 a person. Patty and I sat down and met after this last Tuesday's meeting and had pretty much discovered that we have about 50 people that sit on all of our volunteer boards. Statistically, that's $28 plus the tip, that's $16.80. Now they are allowed to bring another person. If you do that cost, it's $33.60, so $3,360. Then looking at the appreciation mugs, I got two different quotes. The quote that came in the lowest was $775. So I'm looking at a total of $41.35, but that is accounting if all board members and their plus one show up. So I'm asking for up to 5,000 just in case we have more show up than what we were relatively planning on.
Perfect. Anybody disagree with that?
No, I think it makes sense. I think this is part of the reason we have a board discretionary fund is to do things like this. And we always talk about what are ways that we can show that we appreciate our volunteers. And in this, it's a great way as well that we can support a local business with some of that money as well. So I think it's a good idea. To local business. There you go.
Okay, no disagreements. Okay. Are there any comments from the public on this agenda item? No. May I get a motion in a second on this agenda item?
I'd like to make a motion that we approve up to $5,000 for Trustee Teets to expend for the advisory board appreciation dinner.
Second,
Any final comments?
do we need to amend that it will be staff that will be appropriating funds, not Trustee Teets specifically, or I don't know if that matters. Dan's not here. Okay, perfect.
Like coordinating.
Great.
Perfect. All right, may I get a roll call, please?
Certainly. Trustee Gator,
Yes.
Trustee Daly,
Yes.
Trustee Mason,
Yes.
Trustee Teets,
Yes.
Trustee Wiegand,
Yes.
Mayor Pro Tem McDonald,
Yes.
Mayor Shosse.
Absolutely.
Thank you.
All right, we will now end a regular meeting. We will enter into executive session. Can I get
If I may,
I'll adjourn.
Well, we can't
if I may, Mayor Shosse, we need to ask the audience that will not be required for this meeting to leave both physically and on Zoom. So for those on Zoom who are not required to be at this meeting, you will shortly be removed from the Zoom meeting. You will not be allowed to re-enter. Thank you for attending this evening's Zoom meeting.
Perfect. So I
Thank
think we need to
We need
read
to
into
adjourn our
exec.
meeting.
We can't adjourn until after the
Oh,
executive
yes.
session. So I move that we go into executive session for the purpose of determining positions relative to matters that may be subject to negotiations, developing strategy for negotiations and or instructing negotiators pursuant to section 24-6-4024E